For promotional judgment, item number 1 and 2. Criminal appeal 6 of 20 and criminal appeal J 4 of 20.
The impugned judgment and order dated 17/6/2020 passed by the learned Special Judge Fake Nagaland in NDPS case number Sessions Special Case number 7 of 2015 is set aside. Both the criminal appeals are allowed.
Much obliged.
Number 3, WP criminal 14 of 24.
As the initial detention order dated 30/5/2024 is found unsustainable in law, the same is liable to be set aside and quashed. It is accordingly set aside and quashed. In such view of the matter, the subsequent confirmation order dated 30/8/2024 and the extension order dated 2/12/2024 have automatically come in embrace of the legal maxim subleto fundamento credit opus. Consequently, the detainee Kumar Chetri is entitled to be released as his continuing detention under PIT NDPS Act is not sustainable in law. It is therefore ordered that the detainee Kumar Chetri is to be released forthwith if he is not required to be detained in connection with any other case.
Obliged.
Item 4, WP criminal 19 of 24.
Morning, more. The repetition is allowed. It is ordered that the detainee, Baharuddin, is to be released forthwith if he is not required to be detained in connection with any other case.
Item 5, WP criminal 21 of 24.
We therefore dispose of the repetition with the following observations and directions. The detention order, the approval order, the confirmation order, and all other consequential orders are bad in law and accordingly interfered with. We set aside and quash the detention order, the approval order, the confirmation order, and all other consequential orders. The repetition stands allowed to the above extent.
Lord choose.
Ordered matter for admission. Item number 6, WP criminal 13 of 24.
Central government আছে না? Yes, Central Government Council. Are you audible? Mr. Angami,
Yes, Lordship.
are you audible?
Yes, Lordship.
Where is the Central Government Council?
Lordship, no idea, Lordship.
Mr. Yangarvati or Mr. Jed N. Anguli? They were supposed to place written instructions of the Union of
Lordship.
India.
Yes, Lordship.
Vaccines traditionally invented rights. That's why is the amazing country.
Majority is over. It will hold on in terms of the matter of consideration can be put in the following. So it will get a bit over here.
Lordship,
After 2023 4 SSC. This is the correct way, too correct. কিন্তু সিহঁতে এটা conversation যে কিবা এটা কৈছিল না ৰিটেনচন বুক আছে চিঠিখন দিছিল এই ইটো ফাইল ই দুটা ফাইল চাওঁ ই দুটা ফাইল যে মই আৰু দুটা যে আছিল এইবাৰ 3 আৰু 4টো চাওঁ Mr. Siri,
Lordship, Lordship, the other day I failed to point out the delay in serving the
delay in
Lordship.
disposing the representation.
In Lordship. It's in page 51, Lordship.
1 minute.
Point number D, Lordship. Page 51 of the petition, Lordship.
Good morning. Good morning. It will. It will.
Representation for revocation.
In the majority doesn't know how to এইটো মই নগলো কাৰণে আৰু থৈ দিলো এইটোতো দিলে তাৰিখ কৰি দিলো অংকিত অসুবিধা এইটো হি কেপ্টেইন মাইনৰিটি মাইনৰিটি ক'ব খুজিছে ঘৰটো Into to expeditious consideration. As. As. এইটো আমাৰ কেছটো NSA এখন লাগিব নহয় PIT NDPS কিবা ক'ব হৈছে উকিলে ক'ব হৈছে Notice the order made by an official by the state government. Aru central government. Plus এইটো আৰু প্লাছ এইটো আজি ৰিটেন ইনষ্ট্ৰাকচন আমাৰ কথা আছে নাই নহয় টেলিফোন কাউন্সিল নাই Yes, Mr. Siri.
Lordship, I also humbly submit that the state has not taken serious of the representation while dealing with while responding the representation, Lordship. In that matter,
Central government.
May I take
Para
page 7 of the affidavit filed by the state, Lordship.
Page 7 of the
Affidavit filed by the state
filed
respondent.
by the state.
C, Lordship. It shows that the sponsoring authority has responded to the query of Special Secretary after much
Para
delay.
7.
No, Lordship,
Para
para 7C, Lordship. In
C.
page 7. Para 7C in page 7 of the state affidavit filed by the state, Lordship. That with regard to averment made in ground number 9 is denied by the answering deponent. It is pertinent to mention herein that the representation of the detainee was turned down by the detaining authority via order dated 27/06/2024 in finding no merit in the same. It is further submitted that representation of the detainee petitioner dated 11/6/2024 was received by the detaining authority via email on the same day and accordingly forwarded to the higher authority, that is state government, on 11/6/2024. Since the detainee had claimed in her representation that Humble Court of Special Judge NDPS Kohima had via order dated 05/06/2024 granted the full bail to her, para 2 of detainee's representation. Therefore, the state government wrote a letter dated 13/06/2024 to Additional Director General of Police Law and Order, inquiring whether the Humble Court of Special Judge NDPS Kohima was informed of the preventive detention order dated 30/05/2024 passed against the detainee by the detaining authority, that is Special Secretary Home, and was duly served to the detainee by the sponsoring authorities on 03/06/2024. Thereafter, a reminder was forwarded to the same authority via message number so-and-so dated 24/06/2024, 24/06/2024, and accordingly, a reply on the matter was received from Special Branch and SP and DPS on 2706, only on 2706, and subsequently,
Before this.
seen on the reply, the detaining authority rejected the representation on the same day, that is 27th. The sponsoring authority has replied to the query of Special Secretary only on 27th, Lordship. They are not taking serious of the matter, Lordship. The explanation provided by the state is not satisfactory, Lordship. It may kindly appreciate that, Lordship.
Regarding disposal of the representation,
Lordship. More so, Lordship, the Union of India is yet to respond yet to file its affidavit. Ample opportunity has been given to the Union of India, Lordship.
yes,
Ample time has been given to the Union of India to file its affidavit, but they failed, Lordship.
আগৰ antecedent আছে নেকি? Proposal থাকিব লাগে ন?
Nandami, does you have any prior antecedents?
Not recorded, Lordship. But he was in the business since March, as per the records, Lordship.
Lordship, as per the proposal of the sponsoring authority,
22P, 239. Antecedent নাই?
no, Lordship. As per the proposal of the sponsoring authority, the detainee is not involved in any other cases, Lordship. Page 41. Page 41,
Yes,
Lordship. Page 41 of the petition, Lordship. Page 41, point number 13. In the
point number?
point number 13, point number 13 of the proposal for detention.
No.
Page number 41,
Page 41, no.
page 41, Lordship, of the petition. Whether the proposed detainee was earlier involved in such activities? No. Page 41, Lordship, point number 13 of the proposal for detention, Lordship. Page 41 of the petition. This information was forwarded by the sponsoring authority to detaining authority, Lordship. And based on this information, based on these materials, detention order was issued, Lordship.
Detention order too. 7.
Lordship, another ground, Lordship. Lordship, the detention order was not communicated in the strip. She understand, Lordship. Lordship,
Where is the order or a document whereby it was communicated?
Lordship,
Page?
the acknowledgement certificate of the provided by the state in Annexure A of the state affidavit, Lordship.
Oh,
She can understand,
when did you get bail? The detainee got bail in NDPS case?
Lordship,
When he was granted default bail, she was granted
on 5th June, Lordship.
5th of June.
5th of June. Only after the release order was taken to jail for her release, we came to know that detention order has been issued against her on 30th May, Lordship.
May.
May. Only after that. Only after the release order was taken to jail, it was informed that detention order has been issued against her.
Presently judicial custody to get paid to default bail to cover initial stage of investigation, but not to third stage. Where is the bail order?
Annexure 7, Lordship. Page 27 of
Page
page 27 of the petition,
27.
Lordship. Lordship, my apology, 28, Lordship. Default bail. May I be allowed to read, Lordship? This instant IA is filed under section 439 CRPC, read with 167 CRPC for releasing accused persons, namely Nekai Gyute and Mrs. Chinhelin Haukip on default bail. Her Talem Learned Counsel appearing for the accused persons and El Sashimongla appearing for the state, Lordship. Learned Counsel appearing for both the accused persons submit that the accused persons were arrested on 5/05/04/2023 and has been in custody for more than 60 days, and charge sheet is yet to be filed before the court. Therefore, prays for release the accused person on default bail. In the event of their release, the accused persons are ready to furnish reliable surety and abide by the terms and conditions imposed by the court. Learned PP present for the state and submitted that the prosecution has no objection to the release of the accused on default bail, as charge sheet is yet to be filed and mandatory period of investigation has lapsed.
Recent
Lordship, till yesterday, the
নোটিছ অফিচত কিবা মানে এক্সপাউণ্ড কৰিছে নেকি সুধিবলৈ, সেইটো আদাৰৱাইজটো আজিকালি সেইটো ডিছকাছ কৰি দিয়ে না, ওন ষ্টেটমেণ্টৰ ওপৰত বেচিছ কৰি, কাৰণ সেইটো এটা দিছ ইজ আৰ্টিকল কনষ্টিটিউশ্যন কেনট আৰ্টিকল সেইটোত নোৱাৰে ইমপ্লিমেণ্ট কৰিব নোৱাৰে, সেইটোৰ ওপৰত তোমাৰ এক্সপাউণ্ড কৰিছে নেকি? What I mean to say, itu 22 hoga sahi, 21, 22. Protection to heady. 20. No person accused of any offense shall be compelled to be a witness against himself. So this, also another right. No idea. It was in case she does it from your position and have admitted. Well, whether this particular fundamental right, it was a this is fundamental right. No person accused of innocence shall be compelled to be witness against himself. They are taking, there are no other material. Whether it is public, cannot be, I think. You say, we can case this. যদি কিছু করার নাই তেতিয়াহ'লে আধাৰ মিটিংটো হিচাপে কৰিব
তাহাঁতক প্ৰফেশ্যনেল লাইসেন্স যোনটো ইনকাম
আমি সেইটো মুকেশ নগ'লেও দিছ ইজ দ্য অনলি ওৱান ষ্টেণ্ড এলোন পাব এইটো আৰু সেইটো মুকেশ নগ'লেও নাই এইটোতো আছে তুমি এইটো এডমিট কৰা পাৰিবা আৰু বাকী একো নাই there is nothing yeah, there are 2 female occupants with a driver.
Lordship, the other female occupant was discharged by order dated 10/4/2024 by the special judge on the prayer of the investigation officer, Lordship. Page 25 of the petition, Lordship. Page 25 of the petition, Annexure 2. The other lady was discharged on the prayer of the IO, Lordship.
Oh, all right.
Order dated 10th
Yeah,
of 2024.
it has on page 39. Page 39 on 5/4/2024 during routine checking. দুটা আছে আমাৰ লেডি গৰাকী আৰু পাভৈ আইনো Nekhe Guite, there are 2 female occupants along with a driver, Nekhe Guite or Haino. Or you come to Bapui, or Houkeep to Etu Hola, Amadetinu, Etu, come to page 25. Research question. Good. So she's the only one. It is the only evidence is her statement. Article 20 treat water our logo statement of agreement. So he to যদি 161 হয় 161 CRBC এটা তো হয়ে গেছে constitutional. And this is to be part of 21 and 22. It was really okay. It was to below nine. এখানে আবর্জনা যদি আছে ম্যাটেরিয়াল অ্যারেস্ট করেছে এগুলো কেউ but এটু সেগুলো না হলেও পারে ইটস নট টেস্টেড এগুলো পড়ে না পুরো হয়ে যাবে
Because the constitution will be barred.
It will excuse. Reply. Reply. To record করি যে কোনো দিলে কোনো instruction please.
The matter of preventive grievance.
Or no.
Lordship, till
Yes,
yesterday,
the learned Central Government Council is not present.
Lordship.
The call list is out. Call list has been published.
Yes,
Mr.
yes.
Angami?
Yes, yes.
Okay. Heard. Mr. V. Siri, learned counsel for the petitioner, and Mr. K. V. Angami, learned public prosecutor for the respondent state of Nagaland. Full stop. When the case was listed previously on 12/12/2024, comma, Mr. Yangarvati, learned Central Government Council, representing Mr. Jade and Anguli, comma, learned Central Government Council, was asked to obtain written instructions and to place them before the court. Full stop. As no affidavit on behalf of the respondent Union of India was filed till date. Full stop. The written instructions were asked to be placed considering the fact that there was delay on the part of the respondent central government in disposal of the representation submitted by the retinue before it on 11/6/2024. Full stop. And it was after 75 days of making the representation, comma, the central government by its memorandum dated 27/8/2024 rejected the representation. Full stop. Para. Today, none has appeared to represent the respondent Union of India, nor any written instructions on the aforementioned points have been placed before the court for perusal. Full stop. As the matter is of preventive detention under the PIT and DPS Act, and the arguments of the learned counsel for the other parties have been heard substantially, have been heard. As the learned counsel for the parties have been heard on the previous date, have been entirely heard on the previous date, and the case was posted today for placing the written instructions by the learned Central Government Council on the aforementioned point, and no written instruction has been placed today. The case is closed for judgment.
next we can appear for. Now, my lord, this honorable court, my lord, by its order dated 1812, my lord, has allowed a temporary arrangement, my lord, in this regard. If I may kindly pass in. To allow us to, there are in a similar matter. My lord, one of the petitioner, my lord, in one of the cases, he's a person suffering from 80% permanent disability, and the other three, my lord, their capping is still left, my lord. Only 3 attempts they have made, my lord. 4 is the capping, still they are being denied, my lord. We still have one more attempt, my lord.
Okay,
Deeply obliged.
Right, Mr. Lawson. I beg to mention very consider the other side, I beg to number, item number 5 and 6, my lord.
yes.
So there is some personal request, matter may come after vacation, my lord. Petitioner, sir.
Your petition is both?
But I'm the petitioner in item number 6, and when I'm in respondent,
Okay.
in item number 5.
There is consent.
But a concept number.
Yes, sir.
Mr. M. Smith, learned counsel for the petitioner in 6 and for the respondent number 3 in 5 has made a prayer to list the cases on the after in the month of January. It is submitted that MS M. Bora, learned counsel for the petitioner in 5 and for the respondent number 5 in 6 is present and has submitted that she has no objection to said prayer. First of, it is submitted that consent has been taken from the learned standing council, higher education department to make the prayer. First of, in view of the above, comma, the prayer is allowed, list the cases on a date in the month of January after the ensuing winter vacation.
I beg to mention item number 13, my lord. I have taken consent for accommodation only for a day, my lord.
Okay, on the prayer of Mr. J. I. Borhuia, learned counsel for the petitioners, the case is passed over for the day. It is submitted and consent has been taken from the learned counsel for the other sides to make the prayer.
May I please, Lordship? First, I beg to mention for listing as matter unlisted, Lordship. Similar matter is listed before this honorable court today, item number 24 and 26, Lordship. Matter relates to the employment of grade 4 employees, Lordship. Matter relates to the employment of the grade 4 employees where they are working since 2017. Now the respondent authority issued notification for termination of them, Lordship. So, respondent authority issued a notification for termination, they may engage in new one, Lordship. So highly
Okay.
request, Lordship. Yes, highly.
Okay,
Your Lordship, with the consent of the other side, I beg to mention item number 4 of the daily list.
okay. Your Miss
D. Gupta, Lordship,
D. Gupta appearing for
the respondent number 2 and 3.
counsel for the respondent number 2 and 3 has made a prayer for adjournment, comma, with the consent of the learned counsel for the
Petitioner.
with the consent of Mr.
B. Sharma.
B. Sharma, learned counsel for the petitioner. First of, okay. When do you want?
Filed an appeal which is pending before the division bench. It is
Okay.
posted for 27 January. So can it be taken up post that?
27th of January.
Yes.
Okay. Then in the second week of February?
Fine.
Okay. Then counsel for the parties have submitted that the case be listed in the second week of February. First of, the prayer is allowed, list the case in the second week of February on a date to be fixed by the office.
Much obliged.
May I please, Your Lordship? I beg to mention item number 11. Item number 11. Due to some personal convenience, Lordship, my senior is unable to
Okay,
appear.
on the prayer of Miss
A tie.
A.
Tie.
Tai,
Yes.
for the petitioner,
Yes, Lordship.
applicant petitioner. Or the case is passed for the day.
Obliged.
May I please, Lordship? Therefore, district Lordship. Maternity Lordship, pension matter, Lordship. Aspect of
After vacation.
May I please, Lord? Also, I beg to mention item number 9, Lord. Lord, this matter
Yes.
has become infructuous, Lord.
Mr. A.T. Sarkar, learned counsel for the petition has submitted that the subject matter of the repetition has become infructuous. Post of Mr. N.K. Sharma, Guwahati High Court. Item number 19 as well. Mr. H.K. Das was there.
Yes, yes. In this
Hmm?
matter, I am here.
Mr. N.K. Sharma, learned counsel representing Mr. H.K. Das, learned standing counsel, Guwahati High Court, is present. For respondent number 1 to 5 is present. In view of the above submission made by Mr. Sarkar, learned counsel for the petition and the petition having been rendered infructuous, stands closed.
Item number 8, Lordship.
8, yes.
Further time to file our affidavit in opposition.
Okay, so detail us. Mr. H. Betala, learned counsel for the petition is present. Mr. N.K. Sharma, learned counsel representing Mr. H.K. Das, learned standing counsel, Guwahati High Court. For the respondent number?
Only the sole respondent, Lordship, Guwahati High Court.
For the sole respondent?
Sole respondent.
Okay, for the sole respondent. How much time? Has paid for and is granted 2 weeks time to file the counter affidavit on behalf of post of. List the case after 2 weeks.
Me. Obliged.
Affidavit list for motion, item number 14.
May I please, Your Lordship?
Yes, Mr.
Lordship, the this is the contempt
Non-disposal of appeal.
Lordship is. Lordship.
Heard Mr. Chakraborty, learned counsel for the petitioner. This contempt petition is preferred, alleging non-compliance of the direction made in an order dated 14/8/2024, passed in a writ petition WPC number 4054 of 2024. First of it is Mr. Chakraborty has submitted that the copy of the order dated 14/8/2024 was duly submitted before the sole respondent,
Sole respondent.
before the respondent, along with the appeal on 21/8/2024.
Lordship, it was 10 by speed post and it was delivered on 24/8/24.
Okay, was sent by post, registered post on 21/8/2024, and the same was delivered at the office of the respondent on
24/8/24.
Issue notice returnable in 4 weeks. Petitioner shall take steps for service of notice by registered post with AD. Service of notice upon the sole respondent by a registered post with AD within 2 working days from today.
Obliged, Lordship.
15.
Actually, in this case, my lord, the petitioner who is now undergoing my lord, 5th semester of LLB in a Guwahati University Law College, my lord. Now, during the 2nd semester, he was fallen sick, my lord. So he could not appear in the second sessional examination, my lord, 2 papers, my lord. So accordingly, after he recuperated, my lord, he filed an application to allow him to sit in this 2 sessional examination. There is a provision for that also, 26(5) also, my lord. Till date, it has not been considered. Now they filed an affidavit here, my lord. Affidavit, they said, my lord, if your lordship kindly look into the last year affidavit, it was filed yesterday, my lord, 19/12/2024, my lord. Now paragraph, lordship will find paragraph 4 and 5, my lord. These are the 2 relevant paragraphs, my lord. They said, my lord, it is pertinent to 2nd paragraph. That the deponent humbly states that past session.
Paragraph
4, my lord, page 64. Running page. That this deponent humbly begs to state that first sessional examination, so and so, so and so.
Yes.
Now, my lord will see kindly my writ petition, my lord. Page, annexure 39, lordship. Page 7.
Page?
Page, so page 39, my lord, annexure 7 of the writ petition, my lord. So during the entire period, my lord, including the retest period, my lord, I was bedridden, my lord. So regulation 26(5) provides, my lord. Lordship will find it page 31, my lord, of my writ petition. 26(5), my lord.
Yes.
If a student misses any sessional examination for valid
Regulation
reason,
25?
26.5, my lord.
Hmm.
If a student misses any sessional examination for valid reason as evidenced by medical certificate or other authenticate document, the teacher concerned may allow the student a separate examination using the teacher own discretion, my lord. So, my lord, during the entire period, that during the original sessional examination as well, during the, my lord, retest period also, my lord, then I was totally bedridden, my lord, which is evidenced by the medical certificate, lordship. So I filed an application, my lord, before them, my lord, to allow me to to take the seasonal examination, my lord, which they can, as in view of provision, my lord, regulation 26(5), my lord.
No, Mr. Fukon, did you give any consideration to the medical document?
My lord, first,
Because this regulation
my lord,
speaks about
No.
giving consideration to a medical certificate.
my lord, my lord,
You are speaking about holding the examination, sessional.
my lord,
But did you give any consideration?
my lord, I take your lordship straight to page 64, 65 and 66, my lord. Your lordship has just read
I have read paragraph 4 and 5.
5, now 6, my lord. That is vital. Page 66. I will come to the regulation little later, my lord. It's a biased interpretation of the regulation, my lord. Para 6. This deponent humbly states that aforesaid writ petitioner has approached the concerned authorities too late, after near about 1 year, since the holding of examinations, when everything was over, and when the writ petitioner could not legally claim for any retest or separate sessional examination in this regard. A retest has already been, my lord, held prior to approaching of this writ petitioner 1 year.
Is there any limitation for 1 year?
My lord, if it comes to 1 year, man, my lord, then, my lord, it will be back paper. And if we come to page 33, the regulation, annexed by the writ petitioner himself, my lord.
Page?
Page 33 of the regulation, rule 33. My learned friend showed page 31, now page 33. No betterment and back, rule 33, first 2 lines. No betterment back paper shall be allowed in the internal assessment and in practical clinical papers in any semester. It is internal assessment paper. So, my lord, he has
When
come
it is betterment? When it is betterment?
after 1 year, my lord.
No, no.
That is-
Betterment concept is what? Something has been done. Then he needs to better it.
That is one.
That is
aspect.
betterment.
Betterment. Then second one, back.
Now, what is back paper?
Back paper, if one fails.
Any definition?
One fails, my lord.
Hmm?
If
Yes.
one fails, my lord, then he appears in the back paper, my lord.
Neither of the two situation is present here.
My lord, he fails to appear, my lord.
No. Back paper, where is the concept back paper? Any definition?
My lord, kindly turn to this.
My lord.
Internal page 31. My lord.
Page 31.
31.
Any definition of back paper? Because it is quote unquote back paper.
Yes.
In page 33.
Page,
quote unquote back paper.
Milord.
There must be some definition then. Where is that?
Milord, in the annex page 24,
24.
no, Milord, that back paper definition is not there.
Yes. Because you have quoted that phrase.
Milord, Milord, page 31, it will clarify, Milord.
31.
31, internal assessment. Rule 25, distribution of marks, first sessional examination, second sessional examination, then viva voce and group discussion. Now 26, Milord. My learned friend relies upon 26.5. First one. The first and second sessional examination of the odd semesters will be held in the last part of September, November respectively. And the first and second sessional examination of the even semesters will be held in the last part of February and April respectively. He is of even semester. 26.2. The principal in consultation with the teachers will notify from time to time the exact dates of sessional examinations, viva voce examinations, and group discussion seminars.
Otherwise, what is your performance
My lord,
till now? You
my-
are studying in which semester?
I'm in now my fifth semester. I'll appear in fifth semester now.
Ah.
They have allowed me to appear fourth semester. I cleared my fourth semester.
No, other everything is
Yes,
cleared.
yes, my lord. And my lord, what is failed to appear, my lord? There is a decision of this honorable court. May I just place this before my lord? My lord, that will clarify myself. Lordship will kindly receive para 7, my lord. Argument has been made. Failed to appear, what does it mean? This is also LLB, my lord. Averment has been made. Start from there. This honorable court is interpreted. Who voluntarily fails to appear. And based on that, my lord, para 13, the case in at hand is to be considered not merely
I
on
think we'll
technical
take up
aspect.
this on 3rd of January for disposal.
Milord.
For disposal, I think if I allow,
Yes, my lord.
that is a final disposal.
Yes, my lord, I understood, my lord. I understood. But my lord, that may not be to allow me to, if I approve, my
If
lord.
I allow,
Yes, my
if
lord.
I allow,
Yes.
it is a final disposal.
I understand. I
A
understand.
full hearing would be required.
Huh?
Full hearing.
Yes,
would be
no,
required.
interpretation of this regulation is required, but concept of back paper, what is concept of back paper? There is no definition.
Milord. But the,
You come
but
up with that,
but
but
the-
otherwise betterment is what? That once a person has appeared already
Milord.
for that particular purpose.
But the very
And he
word-
wants to better his results.
Milord.
That is not
Yes.
That is not the error,
Not-
Milord.
here. Now, what is back paper? Some deeming provision is there. If deeming provision is not there, then it is also not a back paper.
But that very word, Milord.
And so far as medical certificate is concerned, regulation says if a medical certificate is placed, you have to give a consideration to that. Yes, this is not satisfactory or satisfactory. Thereafter, you have to exercise your discretion as per that regulation, whether I will do sessional or not. But here you are harping on too late, too late.
Milord, obviously, Milord, too
No,
late.
where is
After
the
1 year.
limitation?
Milord, since Milord,
It-
back paper.
Otherwise, there is a duration, used to be a duration
Milord.
that this much attempt, say
My lord, actually.
3 attempts maximum,
Yeah.
plus another stipulation, maybe 3 years.
Milord.
If it is a 5 years, then maybe must be completed within 7 years. Like that university regulation used to be. But
that-
here he is a student, he passed everywhere. except these two. For these two, there is a provision for medical certificate. But there is no limitation period prima facie.
My lord,
Only expression is you have come too late.
my lord.
Lordship,
Let
I
us
want
give
to-
a consideration
Director
on
wants to
third
clarify my
or
last
disposal.
My lord, actually, second sem, my lord, the exam was held in June 23. Result was declared on 3/1/2024. We applied in March 24, my lord. That is
Okay.
the, yes. that
But
is
there was
page
a
21.
retest notification.
Then-
my lord.
We are
It
on
may-
same.
itself.
That medical certificate is
Yeah.
covering that.
Yes.
My lord,
Medical certificate is covering that.
that should have been submitted during that retest period, my lord. But during that retest period,
He was bedridden.
those medical certificates have not been, my lord, submitted.
Okay, he is on the medical treatment up to
Then-
30th May.
My lord,
Your retest was 23rd and 24th
my lord.
May.
But he has come after 1 year,
That,
showing those.
and he is showing us some region also. Let us have on
third.
23rd
My lord,
of January.
I am told that the fifth sem exam will be start from December 29th or so, my lord.
It is
So in
not
a-
second.
No, it is not clashing with.
Clashing, but my,
Sessional is by the teacher only.
yes, my lord. My
It
lord-
is not clashing with university.
No, my lord. That is between the teacher and the student.
Yes.
Yes, I understood. Lord.
With the approval of the principal.
Principal. So, my lord,
So
what I respect-
university examination, everybody has to sit.
yes.
In the sessional, only
It-
this
it is
petitioner is
exception, it
concerned.
an exception.
This
An
is
exception. Yes. I
separate.
understood. Yes, my lord. But my lord, the option may be-
You will
if-
sit in the,
if
you
the
have been
teacher-
allowed,
If the teacher allowed in
No,
during that.
you
yes,
are allowed to sit in the
in between.
semester examination.
Yeah.
You are sitting in the semester examination.
Semester. Yes, my
You
lord.
sit. This is only sessional.
Yes, my lord.
There is nothing to do with that.
Can it be on 9th, my lord, Thursday? 9th January. Instead of
9th.
Third. Third is Friday, my lord.
No.
So
Okay.
9th,
So final consideration.
my lord.
Otherwise, any affidavit not required. If you want to file any reply, you reply.
I have just pointed out, that is there, my lord, the basic.
But discretion has to be exercised on the basis of medical certificate.
Yeah.
You yourself says 25.6 that discretion.
My lord.
Discretion on the basis of the issue mentioned in the regulation itself.
My lord.
That is medical certificate.
Now, though that back
Heard
is not
Mr.
defined, my
B.
lord.
J. Ghosh, Learned Counsel for the petitioner, and Mr. P. J. Fukan, Learned Standing Counsel, Guwahati University. First of, the affidavit, additional affidavit,
There are two
additional,
affidavit they file, my lord. One,
already two, okay.
first,
An additional, the additional affidavit
yes.
filed on behalf of the respondent number 1, 2, 3 has been placed on record. Full stop. List the case on
9th
9th.
of January.
We can have it on 7th also.
yes, my.
My lord. My lord,
7. 7.
But penalty, man, if they take, if the teacher in between, if
By two affidavit, they are opposing. They are filing two affidavits.
Item 16,
Most of them. 7.
My senior MS customer, she's on her way.
Huh?
My senior MS customer, she's on her way. Kindly,
She is
she's on her way.
on her way. Okay. On her way.
item 17,
My lord, your petitioner joined in a service on 13/11/2007 as a demonstrator in the Department of Forensic Science, Guwahati Medical College. Now, my lord, she was promoted in the post of associated professor. in the
These
year
are for dues,
Well, dues
basically
are-
for dues,
dues
and
are-
setting aside some.
Possible fine. I tendered my resignation on 23/2020, and they have accepted it on 25/2000
20 with retrospective effect, which is something unheard of. Now, these are the points your lordship can go into at the time of hearing.
At the time of hearing, right now we can issue notice
Yes,
only.
yes.
Heard, Mr. S. Your opinion? Okay.
Very good.
Heard, Mr. S. Dotto, learned senior counsel, assisted by P. Hukan, learned counsel for the petitioner. Mr. Anybody from health? We are issuing notice at this stage. Mr. A. Soliha, learned counsel representing Mr. B. Gogoi.
Lordship may record my name.
Oh, your health,
Sir.
okay. Standing Council Health and Family Welfare Department for the response number 1, 2, 3. Finance also is there.
Lordship,
H. Soliha, learned technically learned H. Mr. Soliha, A. Soliha, learned Standing Council Health and Family Welfare Department and Finance Department for the response number 1 to 4. And Mr. B. Chakraborty, learned Central Government Council for the Standing Council, Accountant General, Assam for the response number 5. Full stop. The petitioner has approached this court inter alia assailing an order dated 3/4/2020 passed by the state, passed by which is the authority?
My lord, this is a health department. Right?
Principal Secretary or who? What is the impugn order?
Impugn order, your lordship will find at page 25 and actual D. my lord.
Okay, passed. Dated so and so, whereby?
Impugn order at page 25 and 30. my lord.
Whereby petitioner's child care leave for the period from 1/8/2019 to 31/12/2019 was rejected full stop. The petitioner has also challenged an order dated 28/5/2020. Some delay is there.
My lord, the delay in the sense, my lord, in fact, they communicated me, they did not communicate. The order which have, my lord, what they did, when we called
Whereby?
them, they informed in the 2024.
The petitioner's resignation. Dated not like a full stop need to do. The petitioner has also sought directions in respect of her area salary. And for release of the amount accrued in the new pension scheme, in addition to encashment of earned leave, stroke gratuity, etc. Post of issue notice returnable in 4 weeks. As you are appearing.
Lordship, I am
Okay,
appearing.
D Pomeno, A Soliata. Then
For 1, 2, and 3, Lordship.
okay, D Pomeno standing as Health and Family Welfare Department for respondent number 1 to 3. Or H. Olia, Standing Council Finance Department, respondent number 4, B. Chakraborty 5. Huh? As
Lordship, but
Mr.
here in this matter, Lordship, the area salary they are claiming after a period of 3 years, Lordship, that may be recorded.
Well examined.
Yes, Lordship. Because it is.
Okay, Mr. Upoinu has raised a point that the claim as regards area salary and other amounts appears to be still and belated.
Beyond a period of 3 years.
Beyond a period of 3 years. Huh? Observe issue notice. So as Mr. Upoinu, Soliha, Chakraborty, no formal notice likhi dibo. Extra copies by today.
No, my lord.
Possible.
Today, my
Within
lord,
2 working days.
my lord, I have some prayer. My lord, that is, I find some lacuna in the area of respondent. We may be allowed to, my lord, add additional secretary and special secretary as a party.
That you have to do an amended cost title. We don't have nowadays authority
Yes. Yes.
because of the notification.
My lord,
And it will delay the.
what I pray, let it come on the reopening. I'll think whether I should file a fresh or
Okay.
I'll think.
Then 3rd or 6th?
6th will be better.
6th. Okay, on the prayer of Mr. As Dr. Leonard, Senior Counsel is stated by so-and-so petitioner, leaves the case on 6th. Baki reason present থাকা বলে লিখে দিলে হোক, huh?
God bless you.
Item 18,
We should have it after some time, when the learned AG is on his legs now. He'll be appearing there. God bless you.
item number 19,
The area salary of the suspended period, my lord.
Heard Mr.
K.
Uddin, Learned Counsel for the petitioner, and Mr. P. N. Sharma,
For respond number 1.
Learned Standing Council School Education Department for respond number 1.
2, 3, and 4.
Huh?
1, 2, 3, 4.
1, 2, 3, 4. Mr. H. Olia. Learned Standing Council Finance Department for respond number 5 and 6.
Also, 6 has, my learned friend has made finance and secretary to the governor of finance and taxation department, Lordship. It should be just finance department, Lordship, because taxation, it's a different department altogether, Lordship. I just wanted to point it out to you, Lordship.
Finance. It is a separate department altogether or what?
Taxation becomes.
Or taxation, it is a part of finance and
It
taxation.
is a part of finance department, yes. Finance and taxation is a department that does not deal with the education matters, my lord.
But are you a very necessary party as regards the dispute?
Finance be necessary, but finance and taxation does not look into these affairs yet. Finance department. That is.
My lord, I may be allowed to correct this
Then
by hand, my lord.
No by hand. It creates difficulties in the system. Okay. K. Uddin lead you. 3rd of January.
No, my lord, then my lord.
Pension, nothing will go, suspension period. Area salary only. Heaven is not going to fall within these days. Okay, Mr. K. Uddin, Learned Counsel for the petition has sought listing of the case. Better of 6th, I think holiday, he will not able to file amended cost title. Has sought listing of the case on 8th of January 2025 in order to file an amended cost title. Mr. So-and-so are present.
pending matter, item number 16,
I'm awfully sorry, I got caught up.
Yes.
Yesterday, this matter was taken up, my lord.
I forgot everything.
My lord, I'll take lordships again, my lord. The petitioner is serving as a peon in the establishment of the CJM, Borpeta. Now, my lord, peon, my lord.
Okay.
Now, this Honorable High Court had issued an order at page 22, lordship will find for filling up of the posts of process servers by promotion.
Page 22. On the Panini authority, sovereign promotion of sovereign in line to. Okay.
Then Lordship should find that page 24 is the draft rules. It starts. Relevant portion Lordship would find it page 56. Now here I'll take Lordships to two parts. Serial number 16 Lordship will find at the top. For junior administrative assistant, Lordship will find for direct recruitment must be a graduate. For promotion must
We are
be a
concerned with process, sir. Right?
Now we come down to 19, my lord. For direct recruitment, HSLC exam passed. For promotion, must complete 5 years of continuous service in group 2 of the service. There is no requirement of education qualification. Lordship will have page 57, serial number 22. A peon needs to be class 8 pass when he enters. Thereafter, Lordship would find the advertisement at page 70, 4/7/2024. They ask for eligibility. The employee must be HSLC. That HSLC is introduced. I tried to apply. My application is not accepted. And by page 71, one Rijaul Haq, who was 14 years junior to me, is appointed. Is promoted. I'm sorry. I move a application, a representation. Lordship would find it page 73, the last paragraph. I specify that I had tried to apply. My application was not accepted. Page 73. The last paragraph. Without disposal of the same, now at page 80, page 73, Lordship will find the last paragraph. I say that my application was not accepted. Page 73, Lordship finds.
Yes.
My representation, last paragraph. I approach the head administrative officer for consideration of my application after the advertisement.
Anything to substantiate?
My lord, he simply did not do it. He did not take it, so I'm not pressing on that. Then Lordship will have at page 79. I make an RTI.
You did not challenge the advertisement earlier.
My lord, that 4/7 was the advertisement, and September they had made the appointment. And I was a class 8 person. I kept roaming about here and there. Anyway, my lord, at page 79, Lordship will find that in the RTI, I'm told the only qualification requires that I must have completed 5 years continuous service. Now, Lordship will find at page 80 the fresh advertisement.
Yes.
9th day of December, last day is on 23rd of December 2024. They again asked for HSLC, and when I went to apply, they again did not receive it.
Now, what you are challenging now?
My lord,
first process or second process?
My lord, first process, I would like to challenge, because if I had the option, I would be senior to the person who has now been promoted. So I would pray that that be kept subject to account the repetition for the time being. And in case Lordship allows this selection to go ahead, then my application will be accepted. I'll be considered without pressing upon HSLC. And yesterday I had given one promotion order. That person was not an HSLC. He was promoted in Bajali.
Yes, madam.
As per the extent rule.
In other
extent law.
other establishment, without that HSLC.
Yes, the rules are very clear. That's not there. HSLC is not there in the rules.
Draft service rules, they are trying to enforce.
Yes.
And those 5 years is the
only
requirement.
Only requirement.
In other establishment, Mr. Mozumdar is saying that
Somebody has been promoted
without HSLC. Clear your stand. Let him
I will obtain
participate, but not finalize.
No finalize.
We have to test. Maybe some other
yes,
deliberation in the meantime. Heard Mr. Mozumdar, Learned Council for the petitioner. But to accept this representation, you have to show something that you had really made making that statement without any.
Therefore, Lordship will find I have made.
You should have sent it by Easter Post at least.
That I have made the.
That's making a statement without any kind of.
I have also made the head assistant a party.
No, if you are submitting it.
That is all I can do on oath right now. When he refuses to give me a peon, head assistant says, I will not give a receipt. He could not press.
that it
He
remains in
didn't
the,
He did not send a registered in, that's a mistake. I think.
no, it remains in his hand only.
Yes, it remained. They refused. Even this time it has been refused.
If refused by the head assistant,
Yes.
it remains in your
He could
hand
have sent it.
only.
He could have sent it.
I don't know how much about respondent number 7, but
My lord.
yes, this one is different.
But otherwise, respondent number 7, promotion, my lord, there
S. Sharma. Learned. Who is for one? Sorry. CKS Borua, Learned Junior Government Advocate Assam, for the respondent number 1.
2 to 6, my lord.
Ms. S. Sharma, Learned Standing Council, Guwahati High Court, for respondent number 2 to 6. Full stop. The petitioner is presently serving as a peon in the establishment of the respondent number 5. Full stop. The petitioner has the qualification of class 8 pass, but he does not have does not have the qualification of HSLC examination pass. Full stop. Para. The petitioner has projected that by a notification dated 13/2/2020, issued by the respondent number 3, it has been notified that all the appointing authorities of the subordinate court establishments shall uniformly consider the promotion of all eligible grade Roman 4 employees, other than process servers, to the post of process server, in the light of the draft Assam District Court Employees Service Rules, 2018, until the rules are notified by the government. Full stop. As per the draft, within bracket, draft service rules 2018, bracket short. As per the draft service rules 2018, for promotion to the post of process server, one must complete 5 years of continuous service in group D-Roman 4 of the service. Full stop. As per the said service rules 2018, one must have the qualification of class 8 passed for the post of peon, full stop. When a selection process was undertaken by publication of an advertisement dated 4/7/2024, the advertisement prescribed a condition prescribed HSLC examination pass as one of the conditions of eligibility, apart from 5 years of continuous service in grade Roman 4 within bracket D-Roman 2, that is peon and chowkidar. Full stop. The petitioner has stated that despite his efforts to appear in the said process of selection, his candidature was rejected because of his not having a qualification of HSLC examination pass. Full stop. Petitioner has further stated that though a representation was submitted. In that connection, comma, the respondent authorities did not pay any heed to it. Full stop, para. It has been submitted that a new cause of action, a fresh cause of action has also arisen with the publication of an advertisement dated 9/12/2024 by the office of the respondent number 5, whereby a vacancy in the post of process server within bracket jari karak has been sought, is going to be filled up. Post of the petitioner has contended that this time also, on this occasion also, comma, one of the conditions of eligibility has been mentioned as HSLC qualification pass, whereas the draft service rules 2018, which have been made applicable by the notification dated 13/2/2020, has prescribed, have not prescribed such qualification. Full stop. Para. Yes, the petitioner has claimed that he is the senior most peon, second senior most peon serving in the establishment of the respondent number 5. Full stop. In the event the petitioner is not allowed to appear in the selection process undertaken for filling up the vacancy of process server by the advertisement dated 9/12/2024, the petition, which is not in accordance with the notification dated so and so, I got question and notification, and the draft service was dated 2018, the petitioner is like to suffer irreparable loss and prejudice. Full stop. Para. Mr. Mojumdar, Learning Counsel for the petitioner, has further submitted that by an order dated 18/9/2024, comma, a vacancy in the post of process server in the establishment of the Chief Judicial Magistrate Bozali Pachala has been filled up by promotion by a peon by an incumbent holding the post of peon in the said establishment not having the HSLC qualification, pass qualification. First of all, issue notice, the matter will require further consideration. Issue notice returnable on the of February. But having regard, it is noticed that as per the advertisement dated 9/12/2024, comma, the last date for submission of application is 23/12/2024. First of, having regard to the projections made on behalf of the petitioner, comma, this court is of the considered view that as an interim measure, comma, petitioner's application, in the event the petitioner submits an application on or before the last date of submission of application in response to the advertisement dated 9/12/2024, comma, the respondent authorities shall accept the said application notwithstanding the fact that the petitioner does not have the HSLC examination past qualification. Full stop. It is further observed that if in the event the respondent authorities decide to proceed with the selection process, then the results of the selection process shall not be declared without the leave of the court.
The lordships issues notice to the earlier selected candidate, my lord, who was respondent number 7 in the earlier process, my lord.
It is always subject to the outcome.
No, my lord,
The
notice to that person by
the
registered
petitioner has also assailed the selection and appointment of the respondent number 7 pursuant to the advertisement selection process undertaken pursuant to the advertisement dated
4/7/2024.
last the selection and appointment of the respondent number 7 pursuant to the advertisement dated so and so is made subject to the outcome of the writ petition.
Notice by registered post and
Notice by registered post, otherwise they are accepting, except respondent number 7. Petitioner shall take steps for service of notice upon the respondent number 7 by registered post. Baki khini, as MS Mr. Borua has appeared and accepted notice on behalf of the respondent number 1 and MS Sharma. 2 to 5, 2 to 6.
Obliged.
Item 20.
Back to the lordship. Petitioner before your lordship is first wife, my lord. After my.
We will issue notice at this stage. We will decide after appearance of the private respondent. You are fighting with your.
Only thing is that, my lord, petitioner allowed, my lord, thus he is legally entitled to receive and maintain her, my lord. As per full.
No, 1 to 8, let 8 appear.
Lordship, the private respondent who has stopped paying, lordship, so she has to come up with an.
It was your private arrangement,
Yes, sir.
not any government arrangement. Now it has
stopped
to be made government arrangement.
Hello.
Without participation of the respondent number 8, it is not possible at this stage.
In the meantime.
Or I'll stay the pension.
No, my lord.
Then
Only, my lord, half. My half.
then
My lord.
Mr. Borhuya, why don't you understand? You have entered into a private arrangement with that lady.
My lord.
What the court has to do, what the government has to do. So your prayer is also has to be rational at the same time.
Okay, my lord. So long day
Or I'll make it returnable after 1 year. Stay the pension for both.
No, my lord.
Be rational. You have entered into an agreement. Heard Mr. M. Borhuya, learned counsel for the petitioner. Elementary. MS S. Sutia, learned standing counsel, Elementary Education Department. For the respondent number 1, 3, 5. Mr. A. Choliha, learned standing counsel, Finance Department. For the respondent number 2
and 6.
6. Miss Bormon, D. Bormon. D.D. Bormon, learned additional senior government advocate. For the respondent number 4. 4. Full stop. The dispute raised in this petition is regard to apportionment of family pension between the petitioner and the respondent number 8. Correct?
My lord.
Full stop. Issue appear to be the first wife and the second wife.
My lord, petitioner the first wife, my lord.
Respectively of one late
My lord, late allowed the loss.
Ala, A-L-A, Uddin Loskar. Full stop. Issue notice returnable in 4 weeks. As Ms. Sutia has appeared, accepted notice on behalf of so-and-so, Choliha and Bormon. The petitioner shall take steps for service. Returnable data did you? 12. Shall take steps for service of notice upon the respondent number 7 and the respondent number 8 by registered post with AD within 3 working days from today. Post of Mr. Borhuyan and counsel for the petitioner has submitted that the case of the petitioner is fully covered by the full bench decision of this court in read appeal number 160 of 2018 within bracket Musammat Junufa Bibi, Silo page 21 on versus State of Assam and others.
Item number 21.
Mr. Chauhan, do you have any urgency? I'll not take up this matter. Third or sixth? Sixth then. Okay, list this case before any other events without me.
Any reason, Lordship?
The name is of my grandfather, direct grandfather.
Item number 22.
The entire thing was donated by our family. And the name is also of my grandfather.
Yes, Lordship.
And that is only Sanskrit toll in Assam.
It was a pre-independence, initiated in the
Yes, yes, yes.
22.
Would the present petitioner.
Very urgent or what?
Notice.
Suspension. Area. Reinstated.
Reinstated.
Okay.
Notice.
And regularization of that suspension.
Yes.
Heard Mr. R. Islam, learned counsel for the petitioner, and Mr. D. Upamoinu, your standing counsel higher. Standing counsel and standing counsel higher education department for all the respondents. Post up. The grievance of the petitioner, as projected in this writ petition, grievances are that the respondent authorities have not released the petitioner's area salary for the suspension period WEF 7/3/2017 to 12/7/2023 and have not also regularized the aforesaid suspension period. First of issue notice returnable so and so. As Mr. Upoino has appeared accepted. No formal notice, extra copies within 2 working days. The pendency of the repetition shall not be a bar
Yes.
for the respondent authorities to consider the claim of the petitioner, claims of the petitioner on its own merits.
14.2.
It is observed, huh? It is observed.
Item 23.
Yes, Mr. Dotto.
Regarding payment of pension, this stage only I'm praying for a notice, this question.
Notice at this stage. I am Dotto, learned counsel for the petitioner. MS PDAS, learned standing counsel, secondary education department for respondent number 1, 3, 1, 4, 1, 4, 7.
147.
Elementary is also here.
Yes, madam, because.
Okay, A. Choliha, learned standing counsel, finance department for respondent number 2 and 8. H. Chutia, standing counsel, elementary education department for the respondent number 3. MS DD Bormon, learned junior government or senior government, additional senior government advocate for the respondent number 5. Mr. B. Chakrabarty, Lanet, Training Council, Accountant General A&E, Assam Parasarna, 6, full stop. The petitioner has approached this court by this writ petition with a grievance that despite being eligible, the petitioner, the pension and other retirement benefits have not been disbursed, have not been processed and disbursed to the petitioner. Full stop. It is stated that the petitioner has rendered service in Borongini ME School and Uhtoli Borongini Secondary School from 25/11/1999 to 31/5/2023. First of issue notice, returnable on so and so that.
Perhaps respondent number 9 will be registered post, headmaster of the school.
As so and so appeared, so and so. The petition, the extra copies within 2 working days from today, the petitioner shall take steps for service of notice upon the respondent number 9 by registered post with AD within 2 working days from today.
Deplorable. Deplorable. Yes.
Ah, 24. ঠিক আছে 24 একেলগে মাতিব পিছত 26 ৰ মাতি দিম
Item 25.
Ah. 25. Just I mean, nobody. There is no representation on behalf of the petitioner. As today on call, MSD Musari, learned Standing Council,
For secondary education. Your Lordship.
Secondary Education, and Mr. MSD Borman, learned Additional Senior Government Advocate, are in attendance. In view of non-representation on behalf of the petitioners today on call, let the case be listed. Let the case for ends of justice be listed. Is passed over. What are they? Well, just come back.
কিনি হলেও মই আমি কিনি হলেও আমি হয় দে মোৰ বৰ অসুবিধা হৈছে সেইকেইটা চেল নহ'লে মই তুমি চেল কৰি যাব সব কৰি লৈছো চিএডি কেইটা চাব দিবা সব কৰি লৈছো চিএডি চাব দিবা এইকেইটা আমাৰ চোন নাই তাতো চাই মালাই যায় কেইটামান Item 27.
কোনটো একে বুলি
Your
ক'লে?
Lordship, kindly peruse page 25, Lordship. An extra D, Lordship.
25.
Lordship.
Bhavani Hazarika.
Lordship, I was allowed to hold the charge of headmistress, Lordship, by the respondent authorities, Lordship. Thereafter, what had happened, private respondent has filed one writ petition before this honorable court, Lordship, which was subsequently dismissed by this honorable court, Lordship. Thereafter, again, one order was passed, Lordship. Kindly peruse page 41, Lordship. An extra H, Lordship. But till that,
Yes, madam.
At this stage, your lordship, notice may go, your lordship.
You can take instruction.
Instruction will suffice, Lordship.
Heard Mr. P. Bodoloi.
Lordship.
P. Bodoloi,
Lordship.
Learned Counsel for the petitioner. And MS P. Das, Learned Standing Counsel, Secondary Education Department for the respondent number
1 to 3.
1 to 3. Full stop. The petitioner has claimed that initially by an order dated 24/3/2022, the petitioner, who is the senior most,
Lordship. No,
who is an assistant teacher of Gogamukh Girls High School, has been allowed to hold the charge of headmistress in charge of the said school along with financial powers. Full stop. Against the said order, the respondent number 4 preferred a writ petition, WPC number 2621 of 2022, challenging the same. Full stop. By judgment, an order dated 29/1/2024, the said repetition WPC number so came to be dismissed. Full stop. The petitioner herein was impleaded as party respondent number 4 in the said repetition WPC number so and so. Full stop. Subsequent to dismissal of the repetition WPC number so and so by the judgment dated so and so, order dated so and so, the respondent number 2 has passed another order on 29/2/2024, whereby the petition has been allowed to act as the headmistress in charge, headmistress of said school, school to naam to de dibo. Post of para. By this repetition, the petitioner has raised a grievance that despite the order dated 24/3/2022 and 29/2/2022, the respondent number 4,
Lordship.
the respondent authorities have not taken any action to hand over the charge
Lordship.
of the headmistress to the petitioner from the and the respondent number 4 has been illegally
Lordship.
holding thus HR still date post of having regard to the grievance raised in this writ petition, MS Das, the Standing Council, Secondary Education Department shall obtain instruction as to why the petitioner, as to why the order dated so and so and order dated so and so have not been given effect to till date. List the case as sought for by Ms. Das. List the case on
After vacation.
obviously after vacation. I'll not sit for that in the vacation months.
20.
20. Why not before that?
10.
10.
Oblige, your lordship.
Daily list for admission, item number 1.
May I pray, my lord, to take up-
Yes.
Matter is ready for disposal, if lordship pleases, my lord.
Not disposal to
That is why, my lord, that is
oh,
why
be
I'm-
rational at least.
At least, yes, I'm praying that is why, my lord. If lordship, my lord, 2017 matter, I cannot pray for adjournment also. Lordship, fix a date immediately after reopening, my lord.
Okay.
For
A.
final
Somwa,
disposal.
Learned Council for the petitioner. N.K. Sharma. Mr. C.K.S. Borua.
Response number 1.
1. Junior Government Advocate. For response number 1, N.K. Sharma, representing Mr. Iske Das, Standing Council, Guwahati High Court, for response number 2 to 4. Hard Kodibo. List the case on a date in a week commencing from 27th January. 27 January.
Well, fix a date, my lord, 27.
27 January. In a week commencing from.
Well,
real rational life.
Item 2.
Filed the application for substitution by the wife.
Mr. Is it available? No.
No, yesterday on.
Mr. B. P. Bora, Learned Counsel for the petitioner, has submitted that an application for substitution has been filed yesterday.
By his wife. Wife of the.
Has been filed yesterday, and the same is not listed today. Post of. It is submitted by him that that the case be listed after 2 weeks with the application for substitution cover stated to have been filed yesterday on record. Post of Mr. C.
For 3 and 6.
Okay, who are ahead of you?
My head of it.
Chief Secretary, D.D. Borman, Additional Senior Government Advocate. No, Finance. Chief Secretary of Government of Assam Finance Department. D.D. Borman, Additional Senior Government Advocate, Assam for the response number 1. N.K. Standing Council. You are standing on. Mr. Your name? T. Gogoi. Learned Council representing Mr. T.J. Mohanto, Learned Senior Council, and Standing Council, Guwahati High Court, for the response number 2. D. Borman, 1 and 4. Okay, A. Solia. A. Solia, Standing Council, Finance, 1, 5, and 5. C. Burwa, Standing Council, Accountant General,
T and six.
A&E, 3 and 6 are present. Please the case after 2 weeks.
Item 3.
This matter, lordship, may fix this matter after due vacation, lordship, because lordship similar a bunch of matter, lordship, regarding copies typist matter. Lordship has fixed for final disposal on 7th of
Similar
January,
kind of
lordship.
thing. Similar kind.
Almost similar, lordship, but in this matter, lordship, they have not challenged the draft rule, lordship. Otherwise, lordship, similar man.
Okay, Mr.
S. Diffusa appearing on behalf of D. Chaudhary.
S. Diffusa.
Yes, sir.
Learned Council, appearing for the petitioner. C.K.S. Borwa. Learned Junior Government Advocate Assam for the response number 1. N.K. Sharma, H.K. Das, Learned Standing Council. Got a record for respondent number 2 and 3. Anybody for the private respondent? Are present. It is submitted that repetitions, involving similar issue, are ordered to be listed on
7th of January.
7th of January. So no separate affidavit is required.
Those matters, my lord.
Okay. Are ordered to be listed on 7th of January.
7th of January.
7th of January. Okay. And have sought for listing of this repetition also on 7th of January 2025. Full stop. In view of the above prayer, list the case on 7th of January.
Item 7.
For 3 weeks time, my lord, I asked for-
My lord.
Within the vacation, I'll finalize and my lord. I'll
Okay,
just-
Mr. A.K. Azad. Learned Council Porter petitioner is present. Post of Mr. H.K. Das. Learned Standing Council. One record for respondent 2, 1 and 2. Has paid for and is granted 3 weeks time to file the counter affidavit on behalf of the said respondents. Post of D.D. Burman, learned additional senior government advocate, some for respondent 3, Azad or Likidibo. Leads the case accordingly after 3 weeks. On the date
Can I pay that, my lord? After vacation, my
after
lord.
3 weeks.
High level.
Item 10 for orders.
Why it has come for order?
Fixed, your lordship.
Respondent 8 has taken time, your lordship, on the last date to file their affidavit.
Some more time.
Petitioner is not present.
Yes.
There is no representation on behalf of the petitioner today on call. Full stop. Office not dated 22/4/2024 has reported that no interlocutory application has been filed seeking deletion of the name of the respondent number 4. Full stop.
I appeal for the petition also.
Office note says no application for deletion of the name of respondent number 4 has been filed. Despite, I think. It is submitted by the petitioner 26/6/2023 that an interlocutory application will be filed for deletion of the name of the respondent number 4. That is recorded. Office note says no application filed till date.
On next day, I will file it.
I simply adjourn it
Because
then.
nowadays it cannot be deleted without any.
Huh?
Nowadays it cannot be deleted without any application. Otherwise, lordship.
No, it is recorded.
Yes, Lord.
2018 principal selection.
Yes, Lord.
Anything surviving?
Yes, surviving. Lord.
Huh? Surviving.
Yes, Lord.
Okay, Mr. A.R. Sharma. লিখক নতুনকে লিখক। Learned counsel for the petitioner. M.S. Pidas. Learned standing counsel secondary education department for the respondent number 1, 2, and 3. Mr. Upadhyay, you appear for?
8.
Mr. N. Upadhyay, learned counsel for the respondent number 8 are present. Full stop. তাৰপিছত এই অফিচ নোটটো লিখি দিব। Mr. Sharma, learned counsel for petition has paid for listing of the case after 2 weeks to enable him to take appropriate steps for deletion of the name of the respondent number 4 from the area of respondents. As the prayer is not objected to by the learned counsel for the other sides, the prayer is allowed. List the case after 2 weeks.
Item 12.
Vinod Bosumotari. A Boro.
My lord. This is the contempt that I have filed against the interim order, madam. It is page number 13.
Page number?
Page number 13, 13. And this is the third paragraph. In in the interim, it is directed that neither the petitioner nor the respondent, number 4, shall be allowed to hold the post of in-charge principal of Boganidi Higher Secondary School. The inspector of schools of the concerned district shall be allowed to hold the charge of in-charge principal of the said school till the next returnable date. Accordingly, the impugned letter of the appointment of the respondent number 4 as in-charge principal dated 11/5/2023 five transfer shall remain suspended. Thereafter, what happened, my lord? The container number 2, that is in charge, my lord. There is container number 2, that is in charge. They have issued by violating the honorable court's order. That is page number 18. This is the notice. Down below, he has used this office seal and signature of the principal in charge, my lord. Down below, my lord. Page number 18, my lord.
18.
18, yes, my lord.
Zanoni.
Zanoni, yes, my lord.
Zanoni.
Yes, my lord. Down below, there is a seal in the name of principal in charge of Boginedi Higher Secondary School. Again, he has used page number 20 and 21. Same Zanoni also.
Yes. Who is for respondent number 2?
In charge.
What is your explanation?
My lord, I have stated categorically, my lord, I have filed my affidavit, my lord.
No. What is your explanation? Tell me.
My lord,
Tell me.
yes, my lord, when the order was, my lord, I have in paragraph number 11, I have prayed for unconditional apology, my lord. I have prayed for.
Have you handed over now?
Of the in charge, my lord. Distance was very much, so I was asked for some days to look the academic side, and these 3 only with regard to academic, my lord. At that moment,
No. The order was passed on 14/6/2023. And there your name is clearly reflecting as respondent number 4. And it is in the interim that nor the respondent number 4 shall be allowed to hold the post of in-charge principal of Boginodi Higher Secondary School. But these orders are subsequent to 14/6/2000.
Unconditional apology, my lord.
Yes, Mr.
Malad, for the respondent number 1, Malad, in paragraph 3, Malad, I have stated, Malad, that the honorable court order was complied with, Malad. He was not allowed to act as an in-charge principal, Malad. But what has happened, Malad, there is a mistake on the part of the respondent number 1 also. He has allowed him, he has directed him, in fact, to see the academic side because of the personal difficulty to see the day-to-day affairs of the school. It is a mistake on his part. Malad, can we come to para 3 of the respondent number 1? Only the academic side for he was allowed to.
But whatever was order was clear.
That is clear. That is clear. Well, if that has been stopped now, the inspector of schools he is holding the charge.
Yes, now he is holding.
Not doing
inspector.
anything. In paragraph 3,
unconditional apology has been tendered.
Para number 11, my lord.
Para number
11, my lord. Page 32, my lord.
Page 32.
That is the affidavit of the respondent number 2. And the respondent number 1 has also filed the affidavit, page 23, my lord, para number 3. Categorically, my lord, stated, my lord.
This should have been at the very first part of the affidavit, not in the later part, after explaining your position, when there is a deliberate violation. This is not the way to tender apology. Deliberate violation, any order. And what is the response number one version?
Kindly come to page number 23, madam. This is the part of the affidavit, para number 3.
22.
Para 3, madam, next page, madam.
22. Everybody is trying to explain.
Well, no, no, paragraph number 3, madam. I have stated, madam, that the deponent denies that the deponent has allowed the respondent to hold the charge of principal of the school deliberately violating the honorable.
Paragraph number 2. 3.
3, madam. In this regard, the deponent tenders unconditional apology for allowing the respondent number 2 to look after the academic affairs of the school for some period. The deponent respectfully states that the respondent number 2 was allowed to see the academic side of the school as the deponent found it difficult to manage the day-to-day affairs of the school. However, the deponent never allowed the respondent number 2 to serve as in charge principal of the Government Higher Secondary School in violation of the honorable court order as alleged. The deponent stated subsequently the deponent has stopped the respondent number 2 from even looking after the academic side of the school, and the deponent is holding the charge of the principal of the school in all respect in terms of the honorable court order dated 14/6/2023. Now the respondent number 1 is holding the charge. In fact, at that point of time also, Lord, the financial power was with him only. Lord. Only the for some time it was a mistake on his part.
Yes, Mr.
But I left before this one. Because
Then both are rendering apology. Now affairs are being run by the inspector of schools.
that is true.
So as of now, it is, the position is not revealing.
Only thing is that it should not happen in future, my lord.
No, it will not.
If it happens, you come.
My lord, I will come.
A Boro,
Yes.
for a petitioner. D Nuts. Learned counsel for the response number 1. MS SG Borua. Learned counsel for the response number 2. Poster. This contempt petition was preferred, alleging deliberate violation of an order dated 14/6/2023, passed an interim order dated passed in a writ petition, WBC number 3227 of 2023. Post of para. In a writ petition, the contempt petitioner herein is the writ petitioner, and respondent number 2 herein is has been pleaded as the party respondent number 4. Full stop. Para. The petition number, sorry, the respondent number 2 hearing has been implemented as party respondent number 3 in the writ petition. Full stop. On 14/6/2023, para. The court, after hearing the learned counsel for the parties, passed a following order. Passed an interim order dated 14/6/2023. No. After hearing the learned counsel for the petitioner, learned counsel for the respondent number, and on all the respondents, including the party respondent number 4, has passed an interim order on 14/6/2023. Post of the relevant excerpts of the interim order dated 14/6/2023, read as under. Page 13. A to A. Para. That's why the petitioner has averred, the contempt petitioner has averred that despite passing of the interim order on 14/6/2023, the Respondent number 2 was continuing to discharge duties like in respect of academic affairs of the school by subscribing his seal and signature as the principal in charge of Boginodi Higher Secondary School. And the said fact is evident from a notice dated 11/3/2024. Notices that's dated 5/3/2024 and 11/3/2024, annexed to the contempt petition. Full stop. But on notices being issued, both the respondent number 1 and the respondent 2 have appeared and filed their respective individual affidavit. Full stop. Para. In the affidavit filed by the respondent number 1, it has been stated that he had allowed the respondent number 2 to see the academic side of the school as he was finding it difficult to manage the day-to-day affairs of the school. Full stop. The respondent number 1 has further stated that he had never allowed the respondent number 2 to serve as the in-charge principal of Boginodi Higher Secondary School in violation of the court's order dated 14/6/2023. Full stop. It is further stated that he had subsequently stopped the respondent number 2 to look into the academic side of the school. And at present, he is holding the charge of principal in all respects in terms of the interim order dated 14/6/2023. Full stop. Where is your
My apologies before that.
Where?
Before starting of that sentence, in paragraph 3, in this regard, the deponent tenders unconditional apology for allowing the respondent number 2 to look after the academic affairs.
Prior to making the averments, the respondent number 1 has tendered unconditional apology for allowing the respondent number 2 to look after the affairs of the school for some period. First, in the affidavit filed by the respondent number 2. From the affidavit filed by the respondent number 2, it is noticed that the respondent number 2 has first sought to justify his actions in discharging the academic affairs of the school. Full stop. It is pertinent to note that in the proceedings held on 12/6/2023, the respondent number 2 was represented, meaning thereby, he had full knowledge of the interim order. Full stop. The respondent number 2 has sought to justify his actions by stating that he had taken the steps as indicated in the notice dated so and so and the notice dated so and so. And after being asked by the respondent number 1, post of it was after giving some such justification, command the respondent number 2 has admitted the mistakes on his part to be inadvertent once, and ES, and thereafter, sought apology, sought unconditional apology. Post of para. The manner in which the respondent number 2 has sought unconditional apology for violation of the interim order dated so and so does not find appreciation of this court. Post of. Be that as it may, be that as it may, as the respondent number 1 has stated that at present, he is holding the charge of the entire affairs of the school in compliance of the interim order dated so and so. This court finds that this contempt petition does not necessitate to this court does not is not to be proceeded with, having accepted the statements of the 2 respondents, with a note of caution to the respondent number 2. The instant contempt petition stands closed.
Typing method, method number 18.
Lordship have heard the other side already.
Yesterday.
Substantially.
So in paragraph 16, they have said, and may further be pleased to direct the respondents authorities to defer the TET recruitment test and thereby provided sufficient time to the petitioner to prepare the same. If that be the case, the examination is fixed on 29. Question paper, everything is all set. I do not want to argue on merit now. If they want 15 days more, I am going to consider.
Then it's okay, because I do not want to derail also,
Yes.
but otherwise situation
15 days,
is
no problem, immediately after Magbihu.
only grievance expressed by these few petitioners. So I do not want to.
I feel I am in their shoes, because if it's mathematics, I need more time for preparation. Others,
So
it's okay.
actually yesterday, the standing council who appeared,
Yes.
actually, I do not want to derail the process,
Yes.
but some things are in their favor.
Then definitely, Lordship.
So
Certainly,
that is
that's
why I
on merit,
indicated.
I will not make any submission.
That will
So,
do, your lordship. Your
then-
lordship will close it with that direction.
Yes,
Then 15 days.
15 days.
So obviously it will go beyond Bihu.
Beyond days. Minimum 15 days.
Okay. Heard Mr. S. Borthakur, Learned Counsel for the petitioners, and Mr. D. Hoikia, Learned Advocate General, Assam, assisted by Mr. R. Mojumdar, Learned Standing Counsel, Secondary Education, School Education Department, for all the respondents. Full stop. The petitioners have raised a grievance about amongst the number of grievances, amongst the number of reliefs sought for by the petitioners herein, petitioners in this petition. One of the reliefs they have sought for is deferment of the
May I interrupt your worship? May I leave your worship?
Huh?
There is a meeting with the.
Okay, no, what is the exam name?
TETCOM recruitment test.
TETCOM recruitment test, scheduled to be held on 29, 2024. Be deferred for a period of 15 days, at least 15 days.
For some time.
For some time.
From our side, we are saying 15 days.
From for some time, first off. C. Hoikia, Mr. Hoikia, Learned Advocate General, Assam, has submitted that a decision will be taken or has been taken. So the has submitted.
Government is agreed to for it by 15 days.
The state respondent authorities are agreeable to defer the so-and-so test by a period of 15
Minimum
days.
15 days.
Minimum 15 days. Post of. In view of such submission made by the Learned Advocate General, Assam, Mr. Borthakur, Learned Counsel appearing for the petition, has submitted that in the event the so-and-so test is deferred by a period of 15 days, the petitioner will not have any further cause of grievance. Post of. In view of submissions made by the Learned Counsel for the parties, and in view of the fact that the so-and-so test is going to be deferred by at least 15 days. This petition stands closed. We are not observing anything.
No. Highly obliged.
Because yesterday there was no
instruction.
No, not that very much objection. So I reminded that go through this latest two constitution bench. Yes.
I should do first my item 26.
Oh.
Item 26.
Item 26.
My lord, the petitioner before your worship, my lord, they are grade 4 employees in the Polytechnic in Nalbari. Now, my lord, they were engaged, my lord, in 2017, a large number of polytechnics and engineering colleges were introduced, my lord, opened, but my lord, for grade 4 staff, there was no sanction post. Therefore, what the authorities did, my lord, they engaged, outsourced the engagement, and accordingly, these petitioners and many others in all different college, my lord, polytechnics, they were, my lord, engaged by that, my lord, outsourced that particular, my lord, firm. Then in 2019, my lord, the government decided that there is to do away with that outsourcing, and they have been, my lord, all these persons who were engaged by the earlier, my lord, that private party, those are, my lord, paid by the government from 2019. Now, my lord, page 35 is the impugn order by which the petitioners are aggrieved. Page 35. May I read it, my lord? This is, my lord, issued by the Higher Education Technical Department. Subject engagement of grade 4 staff in 2 engineering colleges and 11 polytechnics. The government of Assam, while launching 11 new polytechnics in 2017
and the two new engineering colleges, Barak Valley Engineering College in 2017 and Golaghat Engineering College in 2019, the Higher Education Technical Department was of the considered view that no post shall be created for staff members like attendants, cleaners, sweepers, security guards, etc. in the category of grade 4 in such institutions. My lord, the petitioners, they belong to my lord Nalbari Polytechnic. Although such staff members have been engaged in these institutions due to lack of notified uniform strength of such staff across all such institutions and proper guidelines in the matter of selection criteria and process, disbursement of wages and tenure of the engagement, etc., many issues were faced. In view of the above circumstances, the government of Assam is pleased to issue the following guidelines for temporary engagement of grade 4 staff in the two government engineering colleges and 11 polytechnics listed below. The petitioners, my lord, polytechnic appears at serial number 3. Now, your lordship will kindly see the clauses. Clause 1, the governing body of the engineering college polytechnics will be authorized to engage maximum 17 grade 4 staff on temporary basis. The temporary engaged grade 4 staff must be born in Assam and be from respective district where the institution is located, having initial education in the state, disciplined, medically and physically fit enough to carry out the specified job. Then 3, above 18 years and not more than 40 years of age, minimum class 8 pass. These are the conditions. And then your lordship may come to next page, clause 5. The remuneration of the temporary engaged workforce will be on daily wage basis for unskilled workers as per latest notification issued by the Office of the Labour Commissioner, Assam. One-time concurrence of the Finance Department shall be taken for a period of 5 years. So, my lord, the last sentence, the above provision principles should strictly be adhered to by all the engineering colleges, polytechnics without any exception. So, this is a, my lord, communication issued on 13/9/2024, but signed on 23/9/2024. But I have made a statement, my lord. It was made available in the Polytechnic of the petitioner on Friday, and Monday, my lord, they came to know about it. Immediately, they have approached before your lordship. Now, one aspect your lordship will notice, my lord. Firstly, these persons have been, my lord, employed in engaged for the last 7 years. Now, in view of this office memorandum, they can engage any person. Because, my lord, no protection has been given to them because they have been continuing for such a long period of 7 years, rendering their service. And that is one aspect, my lord. All of them may lose their job. Not only in the polytechnic, and perhaps, my lord, my friends, they have also filed in respect of other polytechnics. Secondly, my lord, clause 2, Roman 3, your lordship will find above 18 years and not more than 40 years of age. Now, my lord, my clients, they have all crossed the age of 40 years. So, my lord, in any case, they'll lose their job. Firstly, my lord, they may not be appointed and engaged at all. It can be, my lord, fixed engagement by any other person. And secondly, my lord, even if they select from the, my lord, persons who are presently being engaged, subject to limitation of 17 persons in an institute, then, my lord, they will be out because of the, my lord, age criteria. Now, question that comes falls for consideration before lordship, my lord, whether they have got any right to continue. My lord, admittedly, they were engaged, my lord, by outsourced firm. Then, my lord, no posts were created. Even now, my lord, they are not creating any posts. It's only, my lord, temporary engagement. So, my lord, after, my lord, the authorities dispensed with the contract with the private party, these persons were continuing. Initially, my lord, that private party, they gave the, my lord, appointment orders. Those I have annexed, my lord, with a particular pay scale and all. And they were getting this all through till, my lord, this notification is issued. And secondly, my lord, if they are dispensed with, my lord, if this is, my lord, followed, then, my lord, they can all lose the job. And even if you, they take from the, my lord, current one, there has to be, my lord, some principle which has to be followed. And age criteria has, my lord, no reasonable nexus with the purpose sought to be achieved. This has not been, my lord, implemented yet. This is only a direction to all the, my lord, institutes. Your lordship will examine the matter. In the meantime, my lord, at least their services should be protected, my lord. They should not be ousted without the leave of the court. Yes, Mr. Upamanyu.
Lordship, as on today, Lordship, we have not terminated their service, Lordship. So this is on assumption, Lordship. It's a presumption, Lordship, that they will be, Lordship.
But it was issued on 39.
Yes, Lordship.
Well,
And
I-
Lordship, we have not yet terminated them, Lordship. So, Lordship, this rate has been filed in assumption, Lordship, presuming that they will be terminated, Lordship. And moreover, Lordship, this OM is a state policy decision, Lordship. So, Lordship,
So for 17 number fixing it,
yes.
that has financial implication.
Yes, Dr.
Because that
Maybe
That-
my lord, your lordship may not interfere with that eventually. But the question is, my lord, can they be ousted from their job in this manner?
But Lordship has not passed any order, Lordship.
And they do not say anything about the persons, my lord, who are continuing for the last 7 years, my lord, they have been exploited their services. And they do not say anything about this.
No,
if
when you have directly come under the institution.
2000.
Otherwise, it was outsourced.
it was outsourced, my lord.
Earlier, it was outsourced.
Outsourced
Page
with,
30, Lordship.
with regular appointment orders in 2020, my
But
lord.
their employer was at that point of time was a contractor.
Yes, my lord.
When you have come under the system?
2020, my lord.
2000?
20. In fact, my lord, we have made this statement at paragraph 3, but this documents also would make it clear, my lord. On page 30, the Director of Technical Education writes to the government that, my lord, this type of engagement has created problem for payment. And therefore, it should be done through the government. Page 30 was the communication. Then, my lord, page 31, the director, my lord, writes to the principals that, my lord, they may engage. Page 31, your lordship will find termination of service and engagement of grade 4 staff. With reference to the subject cited above regarding termination notice served by HRD Commissioner Industry Security Forces, without giving any replacement, you may engage the required number of grade 4 staff, not more than the main who were in position till 31st December 2019, with same wages until further direction. So they are on the payroll of the government.
But without any sanction post, temporary.
Even, my lord, with this OM, which is under challenge, my lord, that also does not create any post.
Doesn't it create
That
any
also
post?
does
So
not create.
your regulation does not come.
No, we are not asking for regulation, my lord.
It is not possible also.
One aspect is, my lord, that one set of ad hoc employees cannot be replaced by another set of ad hoc employees. They are ad hoc at the most, my lord. For 11 months, they have to be engaged by the office memorandum.
Whether, Mr. Upamanyu, whether this will be worked out or not. Taking your instruction, till then at least take your instruction. Are you enforcing it? Because if the persons are found disciplined, medically and physically fit to carry out the duties, what is the problem?
But Lordship, we have not terminated their service. It is
Right.
premature, Lordship. At this stage, it is premature, Lordship. This.
No, but after termination, what will happen?
They can always approach the
Then
court,
they will
Lordship.
come.
But this is only an assumption basis, Lordship.
Whatever, you have fixed the criteria.
Yes,
At least
sir.
they have the genuine apprehension.
But
You
Lordship,
have fixed the criteria. But if it is menial, cleaner, sweeper,
Lordship, financially,
how it is a person above 40 years is not fit to do all these jobs. These are not specialized skills. Sweeper, cleaner, attendant,
security guard.
guards. This is all.
OM also says, my lord, unskilled pay.
One can be fit at 70, 80 also.
Yes, but Lordship.
Medically, physically. He may be more disciplined also.
Lordship, that is true, Lordship, but it's a state government decision.
No,
also.
state, but
And Lordship,
just
we
because
have
it is state, you are not creating any post.
No.
They don't have any right otherwise to get pay skills. fixed pay. That is also fixed. You take your instruction on this office memorandum. Till then, status quo be maintained. If the petitioners are continuing as on date,
Yes.
you take your instruction about whether you are really enforcing it or not. Then we'll consider. If they come up, yes, we'll relax this condition.
Your lordship will examine that.
That we'll examine.
Some group is part of the newly established engineering college of Peninsular, detail and approach on high court. And overall, I could have given, taken the same view.
Let us see.
It is item number 24, page 24.
It was passed on 1/6/2023, Lordship. WBC 3050.
But that is ongoing recruitment process
That is maybe with regard to some.
for making regular appointments.
To replace by another temporary bench.
Here it is clear that they are not creating any post.
Yes.
But same Borak Valley Engineering College, which is one of the two, Borak Valley Engineering College, 2017. If you come to Office Memorandum 35.
Borak Valley number 1, my lord. Borak Valley
Yes.
Engineering College. So they may have, my lord, abandoned the process of regular appointment and their
Scheme of regularization you cannot direct. Seeking a mandavas.
we cannot, my lord. I agree with your worship.
So we can issue notice, don't replace by another set till the returnable date.
In that case, Lordship, can it be fixed on 6th?
Then we can call for instruction. Heard Mr. M.K. Chaudhary, Learned Counsel for the Senior Counsel, assisted by Mr. M. Sharma, Learned Counsel for the Petitioner, Mr. D. Upamanyu, Learned Standing Counsel, Technical Education.
Yes, Lordship. Higher Education, Lordship.
Higher Education Department
1 and 2.
for the respondent number 1 and 2. Full stop. The petitioners, 15 in number, have approached this court stating that they have a common cause of action. Full stop. Para. It is a case of the petitioners that the petitioners have been engaged in various.
No, my lord, we are from Nolbody only, my lord.
No.
I'm sorry.
Been engaged in various menial jobs like attendance, etc. in the Nolbary Polytechnic since the Nolbary Polytechnic established in the year 2017. Firstly, no, not firstly, no, initially as an outsourced employee till 2020 and after 2020, as temporary grade 4 staff directly under the management of the Nagaon Polytechnic till date. Full stop. The petitioners are aggrieved by certain clauses in an office memorandum dated 13/9/2024, issued by the Higher Education within bracket Technical Department on the subject, page 35, engagement of grade 4 staff in 2 engineering colleges and 11 polytechnics. Full stop. In the year 2017, 11 new polytechnic institutes have been established in the state of Assam, and Nalbari Polytechnic Institute is one of them. Full stop. Para. From in the office memorandum, it has been mentioned that the Polytechnic Institute can engage temporary grade 4 staff and on temporary grade 4 staff on temporary basis up to a maximum number of 17. And the governing body would engage those grade 4 staff. Full stop. One of the conditions for eligibility has been stipulated. No, an age limit has been stipulated as one of the conditions of eligibility for engagement of grade 4 staff. Full stop. As per the office memorandum, a person above 18 years, below 18 years, and more than 40 years would not be eligible to be engaged as a grade 4 staff in the Polytechnic Institute. Full stop. The petitioners have projected that since they have been rendering services in the Nagaon Polytechnic Institute uninterruptedly since the year 2017, the such conditions of eligibility would result in disengagement of the petitioners. Full stop. When the petitioner, it has been submitted that when the petitioners have been rendering uninterrupted, continuous and unblemished services for 7 years till date, their disengagement under the taking resort to the office memorandum dated 13/9/2024 at this stage would be an arbitrary action. First of para. Mr. Mr. Chaudhary, Senior Counsel for the petition, has submitted that in the event the office memorandum dated so and so is enforced, the petitioners would suffer irreparable loss and immense prejudice. At this stage, Mr. Upamanyu Lawrence Standing Council. Higher Education Technical Department has, when can you get the engagement? Regarding enforceability, then we'll consider the other thing.
6-1.
6-1, okay. Make it 10-1 or 8-1?
8-1.
8-1 has submitted that he will obtain instruction as regards as to whether the government state respondents are enforcing the office memorandum dated so and so or otherwise. And has submitted that the case be posted on 8/1/2025. Post of list the case accordingly on 8/1/2025. Post of para. Having regard to the projections made on behalf of the petitioners and considering the fact that the petitioners and as stated on behalf of the petitioners that the petitioners are currently engaged in Nagaon Polytechnic Institute. Since last about 7 years continuously, the parties, sorry, the respondent authorities shall not replace the petitioners by taking resort to the office memorandum dated 13/9/2024.
Okay, my objection may be
Till the returnable date. Till 4/8/1/2025. So, okay, Mr. Mr. Upamanu, Learned Standing Council, has contended that since the petitioners are only temporary contractual staff, they do not have any legal right to assail a policy decision taken by the state government regarding engagement of staff in the polytechnic institutes maintained by the state government.
My lord, it is a Nalbari Polytechnic, not
Nalbari.
My lord, may I make a request, my lord? Since we will not be getting the certificate copy today, can your worship direct him to
It will be uploaded. But
He can inform, my lord.
Lordship, I can inform Lordship.
Mr. Upoino, Standing Council shall inform the respective respondents about the order passed today.
Highly obliged.
Lordship, next is Sri Bhumi Lordship district. And there is one more in Sonipur. 24. 22, 23.
Saying, madam, only Borak Valley Engineering College.
How many petitioners?
23, madam.
23 number. Borak Valley?
Engineering College, Bodarpur.
Same office memorandum or what?
Yes, same thing.
It's part of this office memorandum. It is not.
26, page number 26.
26, okay. Borak Valley Engineering College.
Yes.
23 number. Since engaged since what? 17.
Yes.
7. Listed Lordship.
List the 8-1.
Yes, Lordship. And there is one more Lordship, unlisted Lordship. 7001.
Which institute?
There are, madam, all political institute, para 2 I have mentioned, madam, kindly see. Para 2, page 21.
66.
66.
Why you jumble up everything? From where?
Page 21, madam.
Para 2 Lordship.
Para 2.
Para two companies,
Break.
11 to 1 to 11, Sunitpur Polytechnic,
Yes.
18 to 12 to 18, Goalpara, 19 to 24, Sivsagar, at Likhas.
25,
Page
32.
21 or paragraph
Workshop.
2 likha ase. Paragraph 2 second paragraph.
Next is same.
8-1. Highly obvious.
Develop right.
That's only item number 1.
May I please, Your Lordship?
Yes.
Lordship, item number 1 and 2 are similar matters, Lordship. Can be taken up together, Lordship. Lordship, matter pertains to Lordship for not allowing to sitting in examination of BLLB, Lordship. Lordship, I am a physically disabled student, Lordship, having permanent disability, Lordship. Lordship, I have exhausted my 3 chances for sitting in BLLB examination of 3rd semester, Lordship. Lordship, and according to notification dated Lordship 2011, which is in page number Lordship 60, Lordship. Lordship, page number 661, Lordship, more relevant, Lordship. On 5 years, there are 2 boxes, Lordship. On 5 years integrated LLB and LLB honors, Lordship. Time limit for clearing the degree a candidate shall be required to clear her 5 years interested law degree course within a period of 8 years, Lordship, from the date of her 25 admission for the first semester
What
of the
25
course.
admission? What is 25?
Lordship,
Wrong typing or what?
Lordship, the clear copy is on page number 63, Lordship. Actually, it will be clause 25, Lordship.
Better you resort to the original one.
Yes, Lordship.
I find many mistakes because of carelessness in a type copy. Yes.
Lordship, time limit for clearing the degree a candidate shall
Which part? Where?
Lordship, after second paragraph, Lordship, on second box, Lordship. 5 years integrated, Lordship, LLB.
Yes.
Lordship, may I read, Lordship? Lordship, time limit for clearing the degree a candidate shall be required to clear her 5 years interested law degree course within a period of 8 years from the date of her admission in the first semester of the course. Maximum number of back paper, minimum of 3 theory papers may be allowed as back paper in a particular semester for 5 years integrated law degree course. A candidate will be allowed to clear his or her back paper or papers within the prescribed time of 8 years in 5 years integrated law degree course from the date of admission in the first semester, Lordship. I am within the period of 8 years, Lordship. After that, Lordship, the notification was issued, Lordship. On page number 65, Lordship. Here, regarding the 4th attempt, Lordship, it was mentioned, Lordship. Lordship, present petitioner has also only attempted 3 times, Lordship. In 2019 and 2020, that will be clear from page number 44, Lordship.
No, what is this? You're taking me to 65 for what reason?
Lordship, here the university has notified that a student can attempt after his 3 attempt also, he can sit for 4th attempt, Lordship. Although I have been sitting for thrice only in my 3rd semester examination, Lordship. I have seated there only for 3 attempt, Lordship. I have not exhausted my 4th chance, Lordship. But I have filed a representation regarding this, Lordship. A university has still not allowed me to sit in the examination, Lordship. Moreover, I have a medical condition, Lordship. I am a right-handed student, Lordship. And my right hand is completely physically disabled, Lordship. Because of which that time has been that much time has been taken, Lordship, to clear examination, Lordship.
No, when is the examination?
From 31st, Lordship. Already, Lordship, regarding the similar matter, the order has been passed, Lordship.
Lordship,
How
my-
many papers you have?
Lordship, 3 papers, Lordship. My disability certificate is on page 29, Lordship.
Yes, Mr.
My lord,
Fukan.
I take your lordship straight to page 9, my lord.
Right, this order,
Page 9.
done, this order,
A similar order, Lordship.
My lord,
এইটো দি দিবা এটা আছে ইয়াতে if it is within the regulation, otherwise there are many judgments
my lord,
that if beyond regulation, out.
my lord,
No mercy. But forced sons, if it is there,
my lord, as per the petition, my lord, he has exhausted 5 chances. This is 6th attempt, as per page 9, my lord. May I read, my lord?
which
It is
one?
crucial, my lord. Page 9, paragraph 9, my lord. The second, it starts from page 8. We can skip, my lord. Now page 9. It is noteworthy to mention herein that the petitioner had also drawn the attention of the said authority to the fact that he has attempted 3 arrear backlog papers till date. And as per the impute notification number so-and-so, issued by so-and-so, only 4 attempts of arrear papers of LLB program is allowed. Now it is important. Upon inquiring about the same, the said authority had verbally informed the petitioner that on 2019-20, this is first attempt, my lord, he has appeared for his regular examination of 3rd semester. Thereafter on 2021 session, he had not applied. Neither he had appeared for the examination, and subsequently on 21-22 session, to which petitioner had informed the said authority that could not appear. So 2 times he has not taken that those 2 chances, my lord. Due to financial problems and so COVID-19, he could not find someone to write his paper in the examination. In spite of explaining said misery of the petitioner in detail, said authority had denied the petitioner to appear for 3rd semester backlog area examination. Now, this is important, last 5 lines. As such, he has only exhausted 3 attempts in 1920, 23-24, 24-25. And he has filled up his form for appearing upcoming examination, 3rd semester, included 24-25. So there are altogether 6 chances, the current, my lord, 24-25, but he did not avail the earlier 2 chances, my lord, of 20 and 21.
Lordship,
But as per regulation, my lord, it's a continuous process. My lord. He will have to, my lord, take those chances, my lord.
Lordship, as per notification also, it is stated that within 8 years, a student must clear his degree.
That is one aspect, my lord. 8 years, 3 chances, continuous 3 chances.
And at that time, due to COVID-19 situation, I have also filed a representation, Lordship, to allow me for a substitute, Lordship, as I am at that time, it was crucial time. I have seek for a substitute to write my examination.
If we count from 2019,
it is on
my lord,
page 42, Lordship. At that time, I could not get any.
Don't say at the same time.
At that time, Lordship, on page 42. Lordship.
What do you say by this page 65, Mr. Fukan?
my lord.
First 63.
63 about the duration, my lord. 8 years for 5-year integrated course and 3 theory papers. Now, if we come to 65, 4 chance has been allowed for 24-25 session. Who has already exhausted 3 chances, my lord.
Yes.
But the petitioner and the instant matter exhausted 5 chances, though he has not availed 2 chances, my lord. In
Lordship,
20 year 20, my lord, and 2021, my lord, 2 chances were there. He did not avail. So 3 plus 2, 5 chances exhausted.
Lordship may kindly refer to a judgment that has been placed, Lordship. Lordship, here it is categorically stated that it should not be uh, taken in a mechanical manner, Lordship. Nemo legal Lordship petitioner here in 2010 Lordship GL. Lordship, similar facts are there. If Lordship may come to para 7, Lordship, here also serious illness.
There are other division bench judgments. Well, it says regulations. Whatever is regulation, regulation should follow.
Lordship,
it cannot be any leniency. But question is whether chance means not availing the chance.
And this page 69 is also clear down below, my lord. He has come after 16/12, the last date. On 18/12, that was forwarded and recommended by the principal of that particular college. Page
He is a
69.
student of which college?
BRM Government Law College.
The other petitioner, Orijit Sarkar, he has come, my lord, before this last date.
A recent order, Lordship.
But question is deciding whether everything is difficult. And that is why the court has passed that order, interim order. Deciding at this last moment, on the last working day, it is very difficult, all these issues. Otherwise, again, 6 months or everything will be delayed. I think this is the best possible way.
In that case, my lord, the matter has come up for, my lord, motion item on 16th, my lord. So, and at time, my lord, opportunity was given to the university authorities to file affidavit by Wednesday on 16th. But since the Guwahati University authorities could not, my lord, file the affidavit, so, my lord, on 18th, this order has been passed. But he has come.
But here, it is very difficult now for this court.
And he has already
Or not
exhausted.
to, also, it is difficult to ignore this order also.
But he has already exhausted 5 chances, my lord.
Lordship, I have not exhausted.
We'll decide about that, let him sit.
My lord, otherwise it will open a floodgate, my lord. After, my lord, the last date is
Lordship,
over.
I am a physically
The
disabled
last
student,
date is
Lordship.
over.
That does not,
65 pages.
that is not evoking any empathy or sympathy from the court. Because you did not avail 2 chances.
Because of the COVID-19.
Page 67, my lord, the last date. Last date was 16 December, my lord. Clause 5, 67. And as per page 60.
Last date, page 67.
Page 67, clause 5, my lord. The date of examination form fill-up shall be extended up to 16 December 2024. Page 67, my lord. Clause 5 in the middle. And he has come with a representation 2 days later on 18 December, page 69, my lord.
Yes, why you were late?
My lord, may I, with due respect, my lord.
Don't take that again,
No, no,
physical
I-
disability. For 5 years, it is not possible.
No. May I kindly? My lord, form fill up we had done on time. My lord, may kindly have the form fill up page. I'll just show that we were diligent, my lord. Rest is up to my lord. Page 44, my lord, will kindly have for a moment, my lord. 44, 44. That is where we had done the form fill up. Now, in this matter, my lord, what happened is that.
If form fill-up is done, Mr. Fukon?
My lord.
If yes.
And my lord, our 10th semester results was in fact withheld because we didn't appear, we are not allowed to appear for our 3rd semester.
Whether
exam.
in terms of this notification, he has done it, this page 44.
No, my lord.
Page 44?
Page 44, page 45 is
44 it starts, my lord, and my lord, then 46,
46. It was 18th December 2024.
Yes.
Page 46.
No.
After the last date.
No, my lord,
Yes.
this is just the printout. No, this is, we, কোনদিনা কৰিছিল? 16th or আগত কৰিছিল. My lord, this was done with, before the 16th, my lord, before that cut
But why it is reflecting 1812?
My lord, this is the printed receipt, my lord. On this day, we had taken out the receipt, my lord. We got the materials on that day. He took out the materials on that day from online. And my lord, one.
I'll take your statement, and if it comes out to be wrong,
Why not? It
it will be forwarded to the BCA.
My lord, that is the instruction we have from the client. My lord,
It is your statement.
My
If
lord,
it is 16 to, Despite dispute by Mr. Fukon, if you are saying that you have done it before 16, because you have availed enough chances, but if you are still saying that it is before 18 to last dates, you have done it, okay, you will pass the interim order.
The last page is clear, my lord, on 18.
Yes, he is saying that before that he has done it. You verify and come back. You verify and come back. If he is already delayed, then we'll decide. We'll observe it. Heard, Mr. P. D. Medhi, learned counsel for the petitioner, and Mr. P. J. Fukon, learned standing counsel, Guwahati University, for the respondent number
1, 4, 5, and 6, my lord.
1,
No,
4,
my lord, 4, 5,
5.
and 6.
1,
Not 1, my lord, 4, 5, and 6.
4, 5, and 6. Post para. This writ petition is moved as an unlisted one on the last working day of the court in the year 2024. Post para. The petitioner has stated that he is pursuing 5 years integrated BA LLB degree course from Vishnu Ram Medhi within bracket BRM bracket close Government Law College, affiliated to the respondent Guwahati University. Full stop. Para. Full stop. The petitioner has stated that he is suffering from right arm brachial plexus injury in his right arm. Full stop. তাৰপিছত para. It is a case of the petitioner that he has 3 back papers, namely paragraph 7 of the which year you entered?
2018 Lordship.
Pursuing the course since 2018 Lima pursuing below. Full stop. Petitioner has projected that when he made efforts to fill up, when he submitted his applications for appearing in the said 3 back papers by availing the 4th chance in terms of a notification, in terms of the notification number 141, before application, before the last date of submission of application forms, the respondent authorities are not allowing him to appear in the said 3 back papers by availing the fourth Sanch. Full stop. When a representation submitted before the respondent authorities did not evoke any response, the petitioner is compelled to approach this court by this writ petition. Full stop. Para Mr. Fukan Lanet standing also appearing for the respondent Guwahati University authorities has submitted that the petitioner has himself mentioned in paragraph 9 of the writ petition that he did not avail the fourth Sanch for the reasons stated therein, and as such, the petitioner is not entitled to get the benefit under the notification number 141. Full stop. Mr. Fukan has further submitted that the petitioner did not submit his application on or before the last date of submission of examination forms, which was 16/12/2024. Full stop. Para. As per a notice dated 2011/2024, a candidate, a student of 5 years integrated LLB course can clear his her 5 years integrated law degree course within a period of 8 years from the date of his her admission in the first semester of the course. Full stop. The notice has further stipulated that the maximum number of back papers, maximum of 3 theory papers may be allowed as back papers in a particular semester, page 63. For 5 years integrated law degree course, and a candidate is allowed to clear his her back paper or papers within the prescribed limit of 8 years in 5 years integrated law degree course from the date of admission in the first semester. Full stop. Para. The petitioner herein was admitted to the, according to petitioner, he was admitted to the 5 years integrated LLB course in the year 2018, that's 2019. And has not completed. And the period of 8 years to complete the course is not yet over. Full stop. The petitioner has, the General Counsel for the petitioner has categorically asserted that the petitioner has already submitted the examination form on or before the before, on or before, no, on or before 16/12/2024, stipulated prescribed in a notification dated 141, notification number dated 10/12/2024. Postal. Pera. However, considering the short period of time as this court will be closing for the ensuing winter vacation from today within bracket 21/12/2024. In the interest of justice, the authorities in the Guwahati University are directed to permit the petitioner to appear in the back papers, as mentioned here in above, of the LLB 5 years integrated LLB degree course, which is going to commence from
28th.
28th of December.
My
28th?
examination is from 31st.
Huh?
My examination is from 31st.
31/12/2025. It is also made clear that the results of the petitioner shall not be declared by the respondents till the disposal of the writ petition. Para. It is further made clear. It is further made clear that this order shall not be taken as a precedent for other cases in future. Issue notice returnable on. Later, 12/2.
The earlier case was fixed on 23rd. So
Okay, 23rd. 23/1/2025. As Mr. Fukon has appeared, accepted notice, so and so. The learned counsel for the petitioner, extra copy by today kore dibo. As okay.
Non-declaration of result, my lord.
Shall not be declared till the disposal of the writ petition.
Lordship, may kindly allow us to take steps upon respondent number 7, Lordship.
And my lord, that declaration of result shall be subject to the outcome of.
Shall not be declared by the respondents till the disposal of the writ petition, and the same is subject to the outcome of this writ petition. First, the learned counsel for the petitioner shall serve copies of the writ petition along with annexer to the learned standing counsel, Higher Education Department for the respondent number 1 and 2 within 2 working days from today. The petitioner shall take steps for service of notice on the respondent number 3 and the respondent number 7 by registered post AD within 2 working days from today. Post up. Mr. Fukon, in view of the time constraint, the Mr. Fukon learned standing counsel, Guwahati University, shall apprise the respondent authorities in the respondent Guwahati University about the order passed in this writ petition. Otherwise, maybe there will be delay.
Most of it.
Same means what?
Matter is of similar nature, but my lord, the petitioners are not disabled. And my lord, one more fact that I would like to place, my lord, the claim.
My lord, totally different, my lord, regarding backlog, my lord. And they are going to appear in 10th semester, which is to be held in the next year in the month of July, August.
July.
So, my lord,
July,
notice-
then
notice
3rd
may
of
be-
January. Huh?
Notice maybe.
Please look in semester. What is the final year? My lord, they are students of 10th semester, my lord, but the exams that we are praying for, my lord, that we may be allowed, that is for third semester, third and first semester, my lord. That is for the arrear
It
backlog.
has not been stated, my lord. Only the arrear backlog.
No, my lord, it is in my petition, my
Whether
lord, I'll
third,
read, my
fourth,
lord.
fifth, nothing indicated.
May I read, my lord? It is in my
See, the
petition.
other petition was very specific. These are the 3 papers. And I have quoted those 3 papers. Paragraph 3. Paper এখন paragraph of quote করব দিছেন।
Para 4.
My lord, para 4, my lord.
Just backlog.
Petitioners had successfully cleared the, my lord, with due respect, my lord, these petitions, my lord, we are also very sorry, my lord. We have also made in haste, my lord, but it is there in the annexures, my lord, the papers that we have backlogs in, my lord.
Don't try to take the court to the annexers.
My lord, sorry, my lord.
And the last day,
My lord. I'm sorry, my lord, that statement is not there. It is.
why should we go to like make the exercise?
My lord, my lord.
Tell me.
My lord, we have made a statement that we have missed our back papers, my lord.
When your exam is going?
My lord, on 28th of this month, my lord.
Where is your statement?
My lord, well, today only routine has been declared, my lord.
Huh?
Today routine has, Azina? Today only routine has come out, my lord, as per our instruction.
My lord, that 10th semester examination won't be held, my lord, in December or January. It will be held in June, July.
No, they are saying back papers.
Only for back papers.
My lord, back papers will be, my lord, held along with those regular examinations. Odd and even.
Huh?
First, third, fifth, seventh, and ninth.
No, I'm not understanding. They are for back papers are from which semester?
It is not clear. My lord. Page 13, my lord, prayer personal, my lord. Allow the petitioner to appear forthcoming 10th semester.
Huh?
Page 13, my lord.
My lord.
Page 13, the prayer portion. Only to appear in the 10th semester BLL.
My lord,
sometimes it has been written to clear the backlog papers. Sometimes it has been written that they are going to appear in 10th semester. Page 13. 6th, 7th line.
Page 14, my lord, I have categorically.
Mr. Counsel, your main petition is body is of 4 pages. And your prayer portion runs into 6 pages.
From 10 onwards.
Page 10 to 15, 6 pages. And your main body of the petition is 4 pages. I am throwing out this petition, bereft of material particulars to consider.
May I kindly, my lord, just a moment, my lord. I'll just take, my lord, we apologize, my lord, for, my lord, these petitions were made in a haste, my lord. We are really sorry, my lord. You know, this is not.
No, I have given you a liberty to move unlisted motion, but that does not mean that you will
My lord, may I kindly.
throw out everything into caution.
My lord, may I kindly.
Wind.
Sorry. May I kindly have the honorable court's moment, please. My lord would kindly have page 54 for a moment. I think it will be clear. 54 of the resolution. This is of the second writ petition. Deposit not.
We don't know why we should go on reading, Mr. Counsel. Your body of the petition does not show anything. What we can do?
We apologize for that, my lord. We'll file additional affidavit to that, my lord. But
No, Mr. Counsel, I have seen you on an earlier occasion also like this.
my lord, I apologize for that, my lord, but their careers will be at stake, my lord, because if they can't appear.
Just because you cannot take the court for a ride, Mr. Counsel.
That is not my intention.
I have many other orders to do. Everybody has urgency. You are taking the court for a ride.
That is not my intention.
Nothing. In the other case, I have entered in your case. I would have completed my court much earlier. Just because of your case, I have waited.
Deeply obliged. My lord, may I kindly take a moment of my lord's time, valuable time, my lord. Please, my lord. I apologize, my lord. This won't be repeated in the future.
This is too much, Mr. Counsel. Come to your paragraph 4. Read loudly.
That thereafter, as the years roll by, the petitioners had successfully cleared their examinations and reached their 10th semester. However, as the petitioners had missed and not cleared some of their examinations and are having backlogs in the same, petitioner is not allowed to appear for his 10th semester end examination. It is needless to say that only if the petitioners clear the 10th semester end examinations, only then the petitioners would be able to complete their academic course and obtain the degree. Backlogs are there. Otherwise, my lord, 10th semester results are withheld. Will be withheld, my lord.
No, which semester?
My lord,
Which semester back papers?
And prayers are for 10th semester examination, page 13 and 14. Nothing about backlog papers.
Let us see your prayer.
Prayer F.
Court is not going to mold the relief according to submissions.
Page 13 plus F.
Set aside and pass. For that, we have to issue notice. First prayer A. B also. C also.
Forbear from giving effect. D.
would kindly have prayer E for a moment, my lord, page 12.
We'll consider them, we'll direct them to consider on or before. Within 5 days from today. That's all. That's all. We cannot do anything. Only prayer E at this stage.
My lord,
You're not seeking anything, Mr. Counsel. See, don't throw it to the court. Read yourself the prayers. Only thing which can be considered at this stage is prayer E. To consider your representation. We'll ask them to consider.
my lord, that was only one petitioner had only made. We are 3, my lord. 2 and 3 will be deprived then.
Okay, what are the others? Where is that?
My lord,
Where is the others?
there is a statement which I have made in my petition, my lord. May I kindly read, my lord, with the honorable court's permission, my lord.
Mr. Counsel, you are stretching the matter too far now.
I am just stating, my lord, that representation has been made by petitioner number.
Who has drafted the petition? Huh? So who will take the plunge then?
My fault. My lord,
This is not the way.
my lord, para 7, my lord, page 8, my lord. For a moment, my lord, please.
I have read your entire paragraph. Read petition in the meantime. Everything read.
They had approached the authorities verbally, my lord, 2 and 3 petitioners.
Not even preferred any representation. So you are seeking passing. We'll examine that. That is not going to happen to your benefit. How much year you have put in?
My lord.
I can allow all the petitioners to, other two petitioners to submit a representation. At this stage, in the interim, we'll issue notice. Otherwise, no chance. You are wasting the time. Court is not that which can go beyond on its own without any statement sworn on oath, right? You do not have anything, no statement, which back papers, where it is, which semester, it is not there. You did not even submit any representation also, according to you, to two of them, right? You have admitted, you waited. The other one, at least he has shown a form, he has submitted a form.
Yes, ma'am. I know why.
And he made a statement that it was before the last date. Now, after the last date, what can happen? Right, Mr. Will issue notice at this stage and will allow you to submit representations, the other two petitioners, and for consideration on the verbal submission of only. There is no statement that it is going to start from this, that date.
28, my lord, 28. 12.
Now I'm taking your verbal statement. That is not petitioner's statement on oath, Mr. Counsel. How much practice you have put in?
5 years.
Huh?
5 years.
5 years.
My lord, last prayer, my lord, in light of Zabian Farin Chaudhary, my lord, in the
Who's Zabian?
my lord, the single judge order, my lord, WPC 6754 of 24.
You want to distinguish? I'll distinguish them. This. You are taking a risk, Mr. Counsel. Don't test the limit of the court. Mr. Fukon, you examine and see, take a considerate view. If it is possible to be given the chance, you give him them. But on the basis of this kind of materials before the court, it is difficult for, with this kind of prayers.
It's also difficult for me also. Sometimes it is backlog examination, sometimes it is for 10th semester and 10th
Heard
semester.
Mr. P.R. Sharma, learned counsel for the petitioner. And Mr. P.J. Fukon,
For 4, 5,
learned
and 6.
planning counsel, Guwahati University, for the respondent number
4, 5, and
4, 5, and 6. Full stop. 3 petitioners have joined together to institute this writ petition with a number of prayers. As prayer number A, B, C, D,
My lord.
E, and F, Z. Yes.
My lord, I've just got an instruction from my friend, my lord. Petitioner number 1, my lord, Isak Ali. My lord, his results of re-evaluation is out, my lord. He will not take part in the petition. My lord, other 2 petitioners, my lord. Today it has been declared, just sometime back.
Seeking a number of reliefs in the form of prayers A, B, C, D up to I, A, B, C, D up to G. Along with interim reliefs. Full stop. Para from the submissions of the learned counsel for the petitioners, it has emerged that the petitioners are going to appear in the 10th semester examination of the integrated 5 years LLB course from BR.
No, my lord, this is Tezpur Law College.
From Tezpur Law College, affiliated to Guwahati University. Full stop. The petitioners have projected that because of certain back papers in the earlier semesters, they have an apprehension that if the back papers are not allowed to be cleared, the petitioners would not be able to complete the 5 years integrated LLB degree course within the stipulated 8 years time. Mr. Sharma and Council Board of Petitioners submitted that after making submission for some time, has submitted, instruction that he is pressing this application for petition number 2 and the petition number 3 for consideration of his prayer to consideration of their prayer to allow them to sit in examinations. In the back papers, in the back papers in the examination, for the back papers in the examination, which examination is going to be held in a short time from 28 December. 28 December.
28 December, it's for
we don't know the back papers, we don't know anything. Within a very short time. Full stop. Mr. Sharma has further submitted that out of the petition number 2 and petition number 3, which petitioner has submitted representation?
My lord, one had submitted.
Oh,
That is gone.
again another thing. The petitioners, petition number 2 and the petition number 3 may be allowed to file a representation highlighting the issues faced by them in appearing in the back papers. Today is Friday. Tomorrow is open?
tomorrow closed.
Closed. Okay. On the next working day. Next working day. And the in the event the representations are filed, a direction be issued to the respondent Guwahati University authorities to consider the same by taking into account the facts to be highlighted by the petitioners in their representations, along with the rules and regulations in force. First up, para. Issue notice returnable on 23/1 as Mr. So-and-so agonistaকে লিখিব PJ Fukan, বাকি higher education counselor, secondary higher education department, second standing council 1, 2 PJ Fukan accept কৰিলে 4, 5 and 6. The petitioner shall take steps for service of notice upon the respondent number 3 and the respondent number 7 by registered post with AD within 3 working days. Post of. Having regard to the projections made by the petitioners, it is provided, in the interim, that the petition number 2 and petition number 3 shall submit a representation. Shall submit separate representations.
The controller of examination.
Highlighting the difficulties they have faced in appearing for the back papers by Monday before the controller of examination, Guwahati University, within bracket the respondent was 6. And in the event such a representation, such representations are filed, separate representations are filed, the respondent was 6 shall consider shall give consideration to the facts highlighted by the petitioners therein, along with the rules and regulations in force. Full stop. If the full stop. And after such consideration, comma, the decision of the respondent number 6 shall be intimated to the petitioner first by way of a region order. As expeditiously as possible, preferably. Equal rule. Within a period of 3 days.
3 days.
From the date of submission of the representations. That much we can do.
Possible.